Good morning, everyone. We'll call the meeting of the House Agriculture and Natural Resources Committee to order. Each one of you, please log into your stations so we can get your microphones ready. And we'll have the clerk open the roll. Clerk, please take the roll.
Mr. Chairman, we have 15 members present. We have a quorum.
Thank you so much. And we'll start off this morning with a prayer and a pledge. I'll call on Representative Hulsey to lead us in a prayer and a pledge. Everyone, please stand.
Father, thank you for your grace this morning, and thank you for the word of God that it's a lamp unto our feet and a light unto our path. It doesn't just show direction, Father, but it exposes dirty feet. I pray you'll wash our feet this morning, and I pray we'll be found faithful. In Jesus' name, amen. Amen. Salute, pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. Are any personal orders today? I have one. I have a shadow today. Mr. Josh Apt is with us. Josh, if you would raise your hand, we'll recognize you. He's there on the second row, or first row, I guess it is. So thank you for being here with us. Everybody welcome him today. Representative Bain.
Thank you, Mr. Chairman. I'd like to recognize my mother, Julianne, who's sitting in the front row, and my best friend, childhood best friend, Anna Kern, who will be testifying today.
Welcome here. Seeing no others, we will jump right into our business today. We have on our list item number one, House Bill 124. And I probably need to hand the gavel over to Chairman Martin.
Okay, we've had a motion and a second. Chairman Todd, you're recognized.
Thank you, sir. This bill makes some changes to the air pollution laws related to non-Title V air permits and allows TDEC to have a wider range of choices when they're looking at the fees for those particular permits. And it also has some cleanup language dealing with coal ash disposal. So with that, I'll be glad to take any questions.
Any questions? Question's been called. Clerk, if you would open up the board. If you're in the affirmative, vote yes. If you are against, vote no. Clerk, would you give us the total?
Mr. Chairman, we have 15 ayes, 0 nays.
Thank you. The bill passes and goes to Finance. House Bill 0124 pass.
Thank you, Chairman. And we're now on item number 2, House Bill 1325. Chairman Grills. We have a motion and a second. Chairman Grills, you're recognized.
I'm not carrying this bill.
I'm sorry. I've got the wrong name. We've got a whole list of folks on this one. This is Chairman Vital. You're recognized.
Thank you, Mr. Chairman, members of the committee. I'm here on behalf of House Bill 1325, the Tennessee Farmland Preservation Fund. I'm honored to present this bill because this bill is about the love of land. It's the desire to safeguard its natural state for future generations. 1325 helps protect Tennessee's rich agricultural heritage, and significant economic activity across Tennessee are derived from its vast farmland. However, it is at risk. Since 1997, Tennessee has lost 1.5 million acres of farmland. We rank second in farmland loss next to Texas, with a projected loss of 2.2 million acres of farmland by 2040.
Question on the bill. Okay, I apologize.
Representative Vidal, we do have an amendment on this that came out of subcommittee drafting code 5831. Is that what you'd like to attach?
Motion second.
That is correct.
Okay, we have a motion, a second on the amendment. If you're ready to vote on the amendment, all in favor say aye. Opposed? The ayes have it. The amendment goes on the bill. So you're recognized to continue on with that description, sir.
Thank you. Tennesseans now can provide farmers with a pathway to save their farmland while preserving their family's economic opportunities. The Farmland Protection Fund is a tool for farmers and forest owners for assistance for a conservation easement to be placed on their property if they so desire. This program is completely voluntary, exercising the ultimate freedom of choice for farmers and landowners and their families and generations to come. A conservation easement does not mean you lose your land. It protects it in perpetuity. You are still allowed to farm, hunt, fish, mortgage, sell, build a home on your property. 29 other states have implemented similar programs covering over 3.2 million acres. House Bill 1325 establishes the framework for the Farmland Preservation Trust, creates a program to assist farmers and ranchers and forest lands with funds to accomplish this project. At the rate of 10 acres of land an hour, every hour, this bill is here to protect our farmers, reinforce our heritage, and bolster our economy. With that, I know we have some folks to testify, and I will yield to them at your discretion.
Yes, sir. And I know we have members that have questions. So members, if you'd like to wait on the questions and hear from our guest, if I don't hear any objections, we will do that now. We will go out of session to hear from our guest. We are out of session. So first, I would like to call up Miss Emily Stefanik, Mr. Sam Kennedy, and Miss Anna Kern. If y'all would just take one of those seats, and we will recognize each one of you individually. You'll have 3 minutes to give us your testimony, and then if members have questions or comments for you, then we'll come back to anyone that they want to ask questions from. So I guess we'll do ladies first, and we'll start over here on my left. And so I think you, Miss Kern. Just state your name, who you're with, if you're with an association or anything, and we'll have 3 minutes for you. You're recognized.
Thank you, Chairman and Committee. My name is Anna Kern. I'm an 8th generation farm inheritor and a conservation advocate. I come to you today standing on the shoulders of ancestors that fought hard for conservation and land access. Grandparents that founded Ines Nature Center in Knoxville, Tennessee, a now more than 300-acre nonprofit that's enjoyed by over 600,000 visitors annually across the world. Great-grandparents that started a grass-fed Angus cattle operation in the 1940s, and an aunt and uncle that run the same operation today on our 1,000-acre farm, Strongstock Farm, Knox County's largest working farm. A working farm that's been in our family for over 230 years and was a land grant from North Carolina before Tennessee was a state. Our farm has supplied over a ton of meat per month to local restaurants and co-ops for over a decade. Down the road from our farm, you also stumble upon House Mountain State Natural Area, the highest peak in Knox County, and a donation from my family in the late 1980s. Land access and preservation has been in my blood for centuries, and I'm honored to represent Strongstock and our family legacy. Not everyone realizes that working towards conservation easements can be expensive and complex. The legal fees and logistics alone can be burdensome, particularly for farmers who are not raking in a huge profit and tend to put the majority of their money back in their own working operation. This bill will lessen that burden for folks that need it the most, the people that support us in putting meat and produce on our tables at home. As my aunt recalled to me this weekend, we were quick to forget how the pandemic impacted our supply chain. Strongstock close to doubled our beef supply during this disruption of the supply chain at the onset of the pandemic. During those few months in 2020, Communities across the country were faced with the reckoning of the importance for local, accessible agriculture to be prioritized in our counties. This bill is dire for continuing to focus on this necessity. This bill supports the livelihood of farm families and future generations as Tennessee continues to be one of the top states in the nation for farmland loss, an accolade none of us are proud of. I urge you to think about my cousin's son, Henry, a ninth-generation farmer, a 2-year-old who loves nothing more than talking about tractors and chasing sheep, a future farmer whose favorite color is John Deere green. I understand that some of us are concerned that this bill infringes on property rights into the future and is nothing compared with the market pressure to develop this land. My family sees this as the best opportunity to preserve our property rights and the ability to farm in the future. We want to be able to volunteer to do this for future generations for Henry. My family and I understand there are multiple ways to preserve land, but there is immense value to the whole community in preserving land for farm production. Thank you for your time.
Thank you for that. And next we'll have Ms. Stefanik. You're recognized.
Good morning. My name is Emily Stefanik. I'm a conservation project manager for a forestry consulting firm and a member of the Tennessee Forestry Association. As I'm sure you all know, more than half of Tennessee is forested, and about 83% of that is privately owned. Non-industrial private forest land is a huge contributor to the state's economy, with over $21 billion in economic output. And Tennessee is one of the top 3 hardwood lumber producing states in the country. Forestry is agriculture, and forest products are crops. And we are always glad when forestry has a seat at the ag table. Our state forester, Heather Slayton, does a great job at highlighting the importance of timber in Tennessee's agricultural landscape. The biggest challenge facing forest landowners and timber producers is fragmentation from development. Because timber is a long rotation crop and doesn't have annual revenue like row crop and cattle, these producers feel the pressure of development especially acutely. Owning and maintaining land is expensive. The state's investment in this farmland preservation fund will provide an opportunity for forest landowners to continue growing, harvesting, and selling timber products that are so important to our state's economy and rural workforce. This is the type of program that we love to see in forestry. One that not only encourages agricultural production, but also provides a means and an incentive for producers to overcome the hurdles of continued generational ownership. Just want to thank you all for your support of forestry through this bill. Thank you.
Thank you for that. Next we'll hear from Mr. Kennedy. You're recognized.
Good morning, Mr. Chairman and members of the committee. My name is Sam Kennedy, and I own and operate Kettle Mills Farm, as well as I'm a member of the Maury County Farm Bureau Board. We manage about 3,000 acres in Maury and Hickman counties, and I make a professional living turning grass into cattle and sheep. My children are the 8th generation to grow up on our farm, and some of our land has been cared for by my family for over 200 years. I'm also on the Maury County Planning Commission, and like all good farmers, my passion is stewarding the land. I share these things because it lets you know that I'm familiar with the economics of production agriculture and what it takes to own land. I have a long-term perspective of my community and at least a little experience in land use planning. Finally, I'm grateful to have the time to talk to this committee about a subject near and dear to my heart and to express my wholehearted support for this bill. But first, I'd like to take a moment to frame the problem of farmland loss as I see it. We all know that Tennessee is now ranked 2nd in the country for farmland loss. My own county, Maury, is losing almost 1,100 acres per year. There are numerous reasons for this that I won't try to list today, but will state the obvious, that the sum of all economic factors and all policy, local, state, and federal, are driving land to uses other than agriculture. I do not see that trend changing based purely on economic terms. We have reached a turning point in our state. Agriculture has been taken for granted as the default land use, but that is no longer the case. It will take intentional planning on our part, in the same way that we plan for other land uses such as industrial and commercial, if we're going to maintain our agricultural base and we will have to plan for it at the state, local, and individual level. At present, we have no dedicated farmland preservation mission at the state level, and I think Mr. Vital mentioned that 29 states already do. As a planning commissioner, I can tell you that most counties are woefully ignorant at the local level of zoning and planning policies that can help preserve farmland. And finally, conservation easements, one of the primary tools an individual can use for farmland preservation, has been generally unavailable due to its cost of implementation for most farmers. And that's why I'm so supportive of this bill. This is a great start in giving the Tennessee Department of Agriculture the specific task of studying and initiating programs for farmland preservation. I can tell you that there are a host of creative ideas that other states are doing to encourage farmland preservation that Tennessee has not explored yet. And I look forward to having people at the state who can study and learn best practices. I'm also excited that the first tool in the toolbox of this bill is in support of conservation easements. Of course, this tool may not be a good fit for every farm, but is one of the primary tools for individuals to protect their farm and plan for succession. Just in my community alone, I've had 3 farmers in the last month express interest in conservation easements, but
Mr. Kennedy, we ran out of time, but we've got time for questions. And I have first on my list, Representative Fritz.
Thank you, Mr. Chairman. Thank you all for joining us today. My question is on forest land conservancy, ma'am, if you don't mind, because it's a strong interest of mine. So hypothetically, if we had 100 acres of forested land at an approximate value of $10,000 per acre on the market, what would the cost of a conservancy be expected to be on that? And there's a follow-up that you may need to be able to close that. What would that payment per annum or payment in general be to the owner of that farmland to support that easement?
Ms. Stefanik?
Thank you. I can't speak generally to a question like that because all of these specifics are negotiated. There are appraisals that go into conservation easements. I'm not a certified land appraiser, so I can't speak. I can just say that it would vary in my experience.
Representative Fritz?
Thank you. I was hoping for a little more specific answer because 100 acres at 10,000 per acre gives us specific. Do you have any ballpark what that cost of conservancy would be to be able to place that land in conservancy?
You're recognized.
Thank you. So are you asking what the cost to the landowner would be to voluntarily place their property in a conservation easement with an NGO?
Representative Fritz?
Thank you, Mr. Chairman. That's the first question. Yes, ma'am.
You're recognized, ma'am.
Okay. That's not my specialty. As a conservation project manager, I primarily work with landowners who have placed their property in a conservation easement, work with the landowners, work with the NGO to manage the forest responsibly and productively. So I can't speak to that in
Thank you, Mr.
particular.
Chairman.
Committee, we do have Alex Lewis available to testify as well. And some of these questions might be best answered by him. So if Mr. Lewis, if you don't mind approaching, and that last question, if you have an answer for that, we can repeat it if need be, but you're recognized. Just give us your association and answer as you will.
Thank you, Chairman. Good morning, committee members. I'm Alex Lewis on behalf of Governor Lee's office. Representative Fritz, I think that's an excellent question. And I think the answer is much like Ms. Stefanik said, that it depends on the property. We know real estate, all real estate varies across the state. A tract of land in East Tennessee that is dense forest land, well managed, is going to have a different value than forest land in Middle Tennessee. And so at this point, excuse me, the answer is it depends on the piece of property and what the market value might be, and then what the appraised value with a conservation easement would be. So the market forces we can't speak to at this point.
Representative Fritz.
Thank you, Mr. Chairman. Just one last time on this. Thank you. I appreciate you addressing this. So 100 acres at 10,000 an acre should take us to a dollar figure. So it's not speculative. Do we know, let me ask it differently. If we had a pie chart that we were looking at the appraised value of a piece of real estate, whether it's forestry or agriculture, what portion of that pie chart would go to the NGO rather than to the farmer? And what would we expect that per annum or per whatever period incentive to the farmer to be to hold that property in an easement?
Mr. Lewis.
Thank you, Chairman, and Representative Fritz. And it may be more helpful if I back up and describe the program as we've seen it in the 29 or 30 other states that have similar programs. The payment to the farmer or the forester is to compensate for the difference in value between the highest and best market value and then the use value. And so the numbers that you cited is the market value. It essentially takes two appraisals. You have to find the market value and then you have to find the use value. So paying the difference in those two. We've seen in some states that because resources are scarce, some programs in Florida, for instance, does $100 million recurring in this program. So they have more resources on a recurring basis in this program. But we've seen in some states that they essentially, you have farmers and foresters that bid for these conservation easements. And so it's, I know you're not going to be satisfied with me saying again that we can't anticipate every piece of property, the difference in value, or how that would actually play out at this point. But that would be the process that the department would go through, working with folks in other states to learn how to best formulate the program to make sure we can stretch the resources that you ultimately appropriate to the department for this purpose.
Thank you.
Representative Fritz.
Thank
Okay.
you, Mr. Chairman.
Okay. Any other questions for any of our guests? Representative Hurt.
Thank you, Mr. Chairman. I've just got a couple questions for administration there that I would like to ask. And I'll try not to be too long. I've heard in subcommittee, it was touted the Pennsylvania program, and I want to ask this to get it on record. The Pennsylvania Conservation Easement Program that was touted, are you aware it has a climate change criterion in that program? And I would ask if, as we promulgate rules, where that'll be, if at all, in this program?
Mr. Lewis.
Thank you, Chairman. I'm not aware of the specifics of that program as you relate. I will say that program's been in existence since the 80s. And so we will look at that program, but we will take the best of what the laboratories of democracy have produced and build a program that Tennesseans can trust.
Representative Hurt.
And thank you for that, addressing that for us. The next thing would be, we've heard a lot about the family farms and adding this as a benefit toward keeping family farms in the family. In the criterion, or as we move forward with this, is that defined? I mean, how do we know who will benefit from this program? Will it be, where will we be? How will this money be distributed throughout the state? Where will priorities lie? I'm looking at rural West Tennessee, where I'm from. We don't have growth, but I'm pretty sure it's coming. We know we see it in middle and areas of East Tennessee, a lot in middle and a lot in areas of East Tennessee. How will these funds be prioritized through these NGOs in order to benefit balanced across the state?
Mr. Lewis.
Thank you, Chairman. And yeah, as we talked yesterday in your office kind of about this question, again, we have the benefit of learning from the different states, but we will, pardon pardon me, certainly prioritize, and the governor's talked about this, prioritize productive pieces of property, and looking at where we can balance the productivity of the land, either in crop or in livestock or forest land, and then looking at the development pressure that might exist out in your part of the state. Certainly, we anticipate a lot of development as Blue Oval builds out in the coming years. We talked about Murray County and what's happened there as it relates to kind of the implementation of the GM plant and the growth there. So we'll look at all those factors to ensure that we are using this money as best we can.
Representative Hurt?
But as of today, as we look at this legislation, we really don't know. Is that accurate?
Mr. Lewis?
Yes, sir. The legislation doesn't speak to distribution across the grand divisions or anything like that. No, sir.
Representative Hurt?
Thank you, Mr. Chairman. And I just asked the question because looking at the bill and we're talking about $25 million initially. And I think the concept is absolutely, I'm all for it. It's the process of putting this into play where I still have concerns. I do like the concept, and I think it's something we need to be looking at. But we talk about this is something to help urban sprawl. I think I've heard that mentioned between all the committees that this has been through. But I don't see a definition of urban sprawl. I hear an opportunity to save the family or help family farms. I don't see that anywhere where we really know what we're going to get in the end. I know Department of Ag promulgates rules. I have faith in them. But at this time, with the legislation that I have in front of me, I'm struggling to support it. And I think that. We've talked about it. But, we don't know really how the numbers are going to come together. So I think my colleague from East Tennessee asked earlier, and I want to kind of go back to it. As far as the money that the state puts through these NGOs, will that money go directly to the grower? I think you and I have discussed one time, you were talking about using this as an incentive to bring away roadblocks for people going into the program with their land. How does that look to you? Because
Mr. Lewis?
Thank you, Mr. Chairman. And I'll back up and you discuss one of the things that one of your mayors came in and talked about last week was urban sprawl. This bill is about agricultural land and forest land in Tennessee. And it's about helping farmers, as we said, farmers and foresters make the choice, as Representative Vidal said, the ultimate property right choice. And so that is the intent that the governor and the folks that have signed on have shared to ultimately help folks protect land. The money in this program will pass to Tennessee landowners. It is an incentive. It is a payment for them to preserve their land. We are doing that through the nonprofits who will hold the easement. But to be very clear, this is not, these are not grants to the nonprofits for their operations. These are grants to farmers and to forest landowners for the purpose of them preserving their land.
Mr. Chairman, just one more.
Representative Hart, you recognize.
Thank you, Mr. Chairman. I appreciate the flexibility and I appreciate you, addressing my questions. I've got a lot of them and I'm going to wind this up here. I want to make sure we're putting taxpayer dollars through NGOs into programs that already exist. So we're using our tax dollars to incentivize people to put in a program that's in perpetuity. So I just want to make sure that those dollars are being spent as efficiently as possible and not toward, any questions of where they might end up, that they end up to our people. The last question here, and this is, you mentioned I have some folks in my district concerned. Where does this leave planning and zoning authority that the General Assembly has extended to cities and counties if land goes into the program that is planned for long-term growth?
Mr. Lewis?
Yeah, thank you, Chairman. And I understand that question. I understand the concerns that some folks may have. I think to reframe the question, rather than local government's ability to tell property owners what to do with their land, This is about ensuring that landowners have the right to say what happens with their land. So that's the important thing to remember. While at the same time, part of this conversation, and this is why we were so glad to have the support of the Tennessee Municipal League and County Service Association and County Mayors Association, as we were having the conversations about this piece of legislation, we talked about land use planning. And so in the governor's budget, he's proposed a new office of local government planning at the UT Institute of Public Service that will help local governments build out their land use planning. So these are things that are happening simultaneously to help prevent farmland loss, because we want cities all across the state, whether it's small towns or big cities, to have the opportunity to have the community discussions about how they should use their land. And so these are things that are happening simultaneously. They're not happening in isolation from one another.
One thing I'll throw in here that I want to make sure is understood, because this question has come up, and I don't know if the exact answer maybe has been nailed down. So from the funds that are set aside for this, I believe, I understand they are primarily to go to the landowner, not to the NGO, because the NGOs usually are raising money, if I understand, so that they can pay a landowner to give them the trust. Is that your understanding, or what you normally would see?
Yes, sir, Chairman. The money will ultimately go to the landowner, either for the costs that we've discussed, or for the change in value of the.
Okay, thank you. Chairman Martin.
Thank you, Mr. Lewis. First of all, is there a limit on, Representative Prince mentioned 100 acres. I think someone mentioned 3,000 or 300 acres. Is there a limit as to who would be eligible? If I had a 4-acre farm, would it be eligible for this? Or does it have to be one of the big boys?
Mr. Lewis.
Thank you, Chairman. The legislation doesn't set parameters. Those will be built out in the program.
Will that be, I'm sorry.
Chairman Martin.
Yeah, will that be built out? Will y'all bring that in the rules that you will bring to government operations as far as how to make that work?
Mr. Lewis.
Yes, sir. I think that falls into the category of certainly what will be in the rules package that supports this legislation.
Okay.
The department, as you said, will bring before the General Assembly and Government
Chairman Martin.
Operations Committee.
And one more question, when you buy a vacuum cleaner from a salesman at your doorstep, you got 3 days to get out of it. And I guess you could say you got a lifetime to get out of a marriage. If you wanted to get out of something like this, will there be a way to get out of it? And will that be determined in the rules? If you buy a piece of property today, the day you sign the agreement before the day you close, there's a period of time and systems to get out. Can you speak about that and how that buyer's remorse, if you will, or people if they change their mind? Can you talk about that for a moment and how that'll be addressed?
Mr. Lewis.
Thank you, Chairman. Yes, Representative Martin, as we've talked about, this is a permanent easement program that we're proposing. But I think the thing to remember is that these are not insignificant contracts ultimately that the farmers are negotiating or the forest landowners. And so the process to go from an initial conversation with a land trust or with your own family to ultimately the signing and executing of the contract is a long runway that includes both negotiating the contract, but also appraisals and surveys. And so it is a long conversation that we will encourage families to have because ultimately when you agree to place the easement, it is a permanent easement. There are extreme remedies that, a judge can, remove the easement. Those processes do exist. I don't know the extent of how you get into or what you have to prove to get there, but it is a permanent choice that the family's making. And that's not a different permanent choice than selling the land to a developer. Once a family sells the land away, they can't buy it back. It's an equally permanent choice.
Chairman Martin.
I'm good.
Okay. Next, I have Representative Holsey.
Thank you, and thank you for being here. And you and I have discussed several things. I can't get this out of the bill. I've read the bill about 3 or 4 times. My first question is, I'm assuming that when a family sits down with a land trust to hammer out an agreement, that none of these agreements are the same. They're tailored to what the farmer wants. So I'm assuming there's no template that's included in every agreement. Is that correct?
Mr. Lewis?
Thank you, Chairman. I fully anticipate that there are some provisions that are boilerplate, but the actual use of the land, I've seen several different easements that families have agreed to, and they all are different as it relates to use of the land. So yes, they're all different.
Okay.
Representative Halsey.
Listen, I'm 100% in on the purpose. I'm 100% in on saving agricultural land and forestry land. 100%. It turns my stomach almost to drive down old roads that I used to ride my motorcycle on, and it was all farmland and it was all hay land, and now you got housing projects in there. It makes me sick. So I'm right there with you. I am concerned a great deal about things that are not in the bill and protection of making sure these families and these farms stay protected. So that's the reason I ask. If there's a hammered out agreement for this contract for this money, and the hammered out agreement says, yeah, you can build a house here, but you can't build a house over here. You can put a fence here or repair that fence, but you can't put a fence over here. And the farmer agrees to it. Down the road, as technology changes and everything else changes, and the son of the farmer who now runs the farm says, this won't work. I don't want a house over there. I want it over here. And this fence I don't like it, doesn't serve the purpose. I want to put a fence over here. I'm assuming that he has to go back and hammer out and negotiate this with the original land trust group that hammered out this agreement. And that's what I'm asking is, when the interest of the farmer collides with the land trust's interests on the original agreement, who wins?
Mr. Lewis?
Thank you, Chairman. I will point, Representative Halsey, I'll point you to near the end of the bill at the top of page 4, if you're looking at the amendment that you all adopted. Paragraph 5 says the conservation easement must permit the erection, construction, or reconstruction of any building or other structure for agricultural or forestry purposes, and shall not restrict agriculture as defined in Tennessee law or forestry as defined. So to put a really fine point on your question, the easement cannot restrict the use of land for agricultural or forestry purposes. So a farmer can build a barn where they want to build a barn. They can move a fence where they want to move a fence, insofar as that's related to agriculture or forestry. So the easement cannot restrict the use of the land for agriculture or forestry. Those other uses that we talked about in your office and you've asked about this morning as it relates to a homestead place, those can be restricted. And those are negotiated and are in the easement. I'm not a land trust. I can't speak to making those sorts of changes. But yes, it's a contract that ultimately I understand can be renegotiated, but the farmer or the forester wouldn't have to renegotiate to change crop, to build a new barn, to build a new structure that it relates to their farming or forestry operations.
Representative Halsey?
The whole point of all this, it came up last year, is who controls the land. And my point is, if you have to get permission and negotiate, then you don't control. That is a huge thing to me, because I don't want I don't want the farmer to just be the owner of the property. I want him to be the sole controller of the property. And if he has to get permission from a land trust to change or work or do this or do something different, then it is not his option. And therefore, he does not control his own property. Somebody else does.
And thank you. I think I'm really happy that we're having this discussion. The farmer or the forester does not have to negotiate to use their property for agriculture, for farming. They don't have to go through that process if the change is related to the operations of the land.
Representative Halsey.
So you believe, based on number 5 on the last page of this bill, that a farmer, landowner can do absolutely anything he wants to, any way he wants to, even when technology changes, or even if the conservation purpose of the land trust might even include the words protection of natural habitat. When that comes into conflict with the landowner, and that's what the land trust wants and was hammered out in their easement, what keeps them from saying, look, just like the snail darter, you can't do this or you can't do that because of the preservation of the habitat that's on this land, or in the forestry issue, same kind of thing.
Mr. Lewis.
I'm not against you at all, my friend. I want to make sure that the landowner controls his own land.
Mr. Lewis.
Thank you, Chairman. Yes, I think the law that you all pass, should you pass this law, would trump the contract. And so as long as the farmer or forester is doing agriculture as defined in law, or forestry as defined in law, that operation, the forester or the farmer's ability to do that would trump the contract.
Representative Halsey.
As my colleague said up there, word perpetuity in the bill, but you use the word permanent, and it's the same thing. You do realize Leviticus in the scripture says, don't ever put your land in perpetuity. This is a big troubling thing to me. What I wanted last year when we talked about the bill is not go more than 15 years and then renegotiate and make another contract. This goes forever. And that really troubles me.
Thank you.
Representative Shaw.
Thank you, Mr. Chairman. Let me stop them. This is voluntarily, though. Is that right?
Mr. Lewis.
Yes, Chairman, it is.
Representative Shaw.
So it is me and my family who decides this. And if we decide we don't want this, there's nobody to force. This is just another tool, I understand, in the toolbox if a farmer want to use it. Would that be fair?
Mr. Lewis.
Yes, sir.
Representative Shaw.
I guess that's what I needed to hear. I think I understand all the other pieces of it, but I just want to make sure that there's nothing that says I have to do this unless I decide, me and my family, that I won't do this. I just want to make sure that that's clear.
Mr. Lewis.
Yes, sir. This
Okay.
this participation in this program is completely voluntary. The state's not forcing anybody to do anything.
Thank you.
Next, I have Chairman Grills.
Thank you, Mr. Chairman. And I know no time's becoming important. So, Mr. Stefanik, I'd ask you this question. I believe you say you deal with NGOs all the time, and you've been doing these land trust and land preservation, executing these contracts for quite some time. Is that correct?
Ms. Stefanik.
Chairman. So my role primarily is to work with landowners who have placed their property under a conservation easement, work with the landowner and work with the NGO to manage their forest productively, responsibly, and successfully.
Chairman Grills.
Thank you, Mr. Chairman. So, looking at all the different contracts that different landowners have maybe gone into with these NGOs, have you ever seen one that did not have some reference to climate change or some requirement to some type of climate issue?
Ms. Stefanik?
Thank you, Chairman. Yes, I have seen several conservation easements that do not reference climate change or have requirements for maintenance of climate regulations.
Chairman Grills?
Okay, thank you, Mr. Chairman, and thank you for clarifying that, because after Representative Hurt made his reference, I was thinking about, I would be fearful that if we were to give control over Tennessee land over to some environmentalists who do not have Tennessee's best interest at heart, in my opinion, or Tennessee's farmers' best interest at heart. So you very much have clarified that for me, and I really appreciate it.
Representative Fritz?
Thank you, Mr. Chairman. I can save my question for the sponsor. It's for sake of time.
Okay. And we have Representative Travis.
I make a motion to go back in session.
We have no one else on our list, and we do have a request to go back in session. Without objection, we will go back into session. Thank you, guests, for being with us today. We're back in session, and Representative Hurt, I had you first on the list. Did your answers get taken? Okay. And Representative Fritz, you're recognized.
Thank you, Mr. Chairman, and I appreciate the good discussion on this. I'll just go back to something was said with a question. I know my friend and representative carrying this today understands these matters in many ways much better than I do. We talked about as long as it's agriculture or forestry related, there wouldn't be any prevention of a landowner doing what they wanted to do. But let's go back to my 100-acre analogy again. And whether it's in forest or pasture, if I decided I wanted to take a half acre and build my kids a swing set, or my grandkids a swing set in the middle of that, and maybe a slide, and I was going to take up a half acre, do you think I'd be in violation of the conservancy that we've talked about?
I want to see that slide, but Representative Vital, you're recognized.
Thank you, Representative Fritz. Obviously, a conservation easement designates areas for home building, envelopes for agricultural buildings. You can have recreation, family playgrounds, gazebos around ponds. Usually that's designated, but you wouldn't put it in prime sensitive locations that might be valuable for habitat or for protection. I personally have had conservation easements for over 19 years. I'm one of 500 people in Tennessee who protect almost 200,000 acres with voluntary conservation easements. I've never had a problem where I have had able to do anything with my property. But if there's a question, I run it by my land trust and they say, well, you know, here's a better best practices. This is all about best practices. I've prohibited solar power on mine because I don't think that's a best practice, whereas others do. I have no climate change or resilience in mine, but it's about best practices.
Representative Fritz.
Thank you, Mr. Chairman. Thank you for the answer. I appreciate that. I would just offer my last thought on this. I said some of this last week. It concerns me that we are removing the decision-making from the property owner. We're enticing that with public dollars to do so. And we're going to put a conservation purpose on these pieces of property that the owners are in perpetuity required to adhere to. I think that's probably not a wise thing. I can't support it. I appreciate the conversation, and thank you, Mr. Chairman.
Representative Vital.
I would just say this decision is not for everyone. It's just as complicated as deciding to sell that 30 acres at a busy intersection for a Walmart. There's no going back.
We have Representative Doggett.
Thank you, Mr. Chairman. And when I've spoken to some folks back home about this bill, I think about how it might be applicable to someone that might have a large parcel of land, river bottom, good, rich, dark soil that they would utilize. It probably wouldn't be suitable to build a subdivision or develop commercially, but it would be something that this would probably be very beneficial to. But then I look at maybe the family farms. We've got several multi-generational farms where they have inherited from dad or grandpa or whoever, that now as adults, the inheritors, maybe they see that the aspects of their farm is not as profitable as it once was. And so they look to, and if it was in this preservation trust, and maybe they look to other ways to generate income. And so one of the things that's really popular around where I'm at is, they may work cattle, they may work some crops, but they also have like a pumpkin patch or something like that, to where they've got it set up where you can come in and buy mums and pumpkins, but they also have areas for kids to play hay rides, big tall hay castles, corn mazes. Would this prevent them from being able to do this on their property if that's what they chose to do?
Representative Vital.
Absolutely not. We encourage that, and you'll see that quite often with multifaceted agricultural or home-based businesses.
Representative Doggett.
I'm good. Thank you, sir.
Next, I have Representative Travis.
Question on the bill.
We don't have anybody else on our list. Previous question's been called. Anybody object to that? Seeing no objection, we'll be voting on House Bill. Turn my page back here. 1325 as amended. All in favor, vote aye when the board is open. And clerk, please open the vote. Something's not working, clerk. Can we do a reset? All right, now try it. Nope, still not working. If you can, clerk, please call the roll. Take the vote that way.
Alexander. Bain. Darby. Doggett. Fritz. Grills.
Yes.
Halsey.
No.
Hurt. Jones. Reedy. Shaw. Stinnett. Travis.
Yes.
Vital.
Aye.
Martin.
Aye.
Todd.
Aye.
Mr. Chairman, you have 13 ayes, 3 nays.
Thank you, clerk. And House Bill 1325 as amended moves on to GovOps. Next, we'll call up item number 3, House Bill 940 by Leader Camper. We have a motion and a second. Leader Camper, you are recognized on House Bill 940, and I think you have an amendment to propose.
Thank you, Mr. Chairman, committee. Yes, I do.
Let's get the drafting code on that.
The
because we
drafting
have
code-
several.
The drafting code is 6790.
All right, 6-7. That's amendment number 2, folks. If you have that on your dashboard, this rewrites the bill. Do I have a motion on the amendment? We have a motion. We have a second on the amendment. You're recognized. Well, we'll go ahead and put the amendment. It rewrites the bill?
It does.
Okay. If you're inclined, then we will put the amendment on. All in favor, say aye. Opposed? The ayes have it. The amendment goes on the bill. So you're recognized on the bill as amended.
Thank you, Mr. Chairman. Mr. Chairman, members, this bill was inspired by the tragic incident that took place a couple years ago that took the life of Senator Roy Herron by way of a personal watercraft driven by a young boy whose family had no insurance. And initially, we were proposing a bill that would require insurance on these watercrafts so that the young lady who was also injured in the accident would have had some recourse. After a lot of discussion in the prior committee and with other stakeholders, we recognized that no boats or any watercrafts are required to have insurance. And we thought about trying to address that, but we agreed that we would deal with the insurance part next year because the caption in this bill was not wide enough to deal with the insurance aspects of it. The amendment, what the amendment does is changes the age limit in which a person could operate one of these vehicles. It's simply one sentence that's raising the minimum age of operation of a personal watercraft from 12 to 16. And that's all the bill does now.
Okay, thank you for that. I have Representative Doggett on our list first. You're recognized, sir.
Thank you, Mr. Chairman. Would this language be applicable to like a flat bottom boat with a trolling motor on a creek?
Leader Camper.
I don't think so. I have to double check. I think it's the motorized vehicle, motorized watercraft vehicles.
Representative Doggett.
Mr. Chairman, can we access our esteemed legal services? to
Yeah.
Get some
We
further
certainly
explanation?
can. If there are no objection to going out of session here from legal, we will go out of session. We're out of session and we will have legal answer that. You're recognized.
Alexander Greenberg, Office of Legal Services. I can read you the definition of personal watercraft. It is personal watercraft means a mechanically propelled vessel that is designed to be operated by a person sitting, standing, or kneeling on the vessel rather than being operated in a conventional manner by a person sitting, standing, or kneeling inside the vessel. It includes, but is not limited to, jet skis, wave runners, sea-doos, wet jets, aqua jets, Polaris, tiger sharks, and similar crafts. So that's the definition. Thank you.
Representative Doggett, does that answer your question? You look more confused.
Mr. Chairman, I know you utilize flat bottom boats and trolling motors. What is?
From that definition, I believe they are excluded from this bill.
Okay, well then that works for me then. Thank you.
Okay. We have another question. Representative Travis.
Yes, this is for legal also. What is the age on a person for just a watercraft in
Legal.
the state of Tennessee legally?
I don't know if there's a minimum age, but there's a lot. They're going to look that up. I don't know if there's a minimum age, but I do know there's a boating license required now for a motorized boat. So that we'll get that answer from them here shortly. Any other questions while we're out of session? If it's okay with the committee, I'll have legal run that through me while we're back in session so we can get to any other questions on this bill. Without objection, we'll go back into session. We're back in session. Any other questions for the sponsor on this? So this bill has been narrowed down to just the age requirement. I verified that. It does not affect insurance whatsoever. We'll pause for just a moment to get that answer. Representative Vital, you're recognized.
Thank you, Mr. Chairman. Thank you for bringing this bill, and I think we all have great respect for the member who passed away in this terrible accident. He welcomed me when I first came to the legislature, and I think his memory is well served by what you're trying to do. There is a question on those who fall in the category between 13 and 16 now, who are legal. How would they be treated? Would they be banned from driving personal watercraft?
They would have to be with an adult 18 or older.
Okay, thank you.
Mhm.
We're still wrestling through the question that was answered previously. Catching legal off guard on something like that can take a few minutes. If y'all read through our code, you would know that very explicitly. Chairman Martin, you're recognized.
So going back to Chairman Doggett's question about the trolling motor and the boat, when I heard them read that, they mentioned watercraft, tiger, sea-doos, et cetera. But it didn't say that was the only, it just said it included them. And I go back to thinking about when I was a young boy, my grandfather made me a boat that had a little 6 horsepower engine on it that I just went around in the slough in. And it sounds to me like that would be illegal for my grandfather to have given me that boat. And when I was 12 or 13 years old, is that what we're understanding here? It's not just about the Sea-Doo. It's about fishing up a creek with a little 6 horsepower or an electric motor. Would that not be included, Chairman, is my question.
We can go back out of session and ask legal again to clear up a couple of questions, but my understanding of what they read was, to me, the key word may be on. You're on that, like a straddle of that machine versus within it, like a boat. But Sea-Doo makes boats, as you probably know, jet boats that you are inside of, you're not on. So I think that may be what it comes down to. But again, if legal is ready to answer either of those, we can go back out of session without objection. So we'll go back out of session. We're out of session. We'll go back to legal.
Alexander Greenberg, Office of Legal Services. I can read the first part of that definition again to give you more clarity. Again, it says personal watercraft means a mechanically propelled vessel that is designed to be operated by a person sitting, standing, or kneeling on the vessel rather than being operated in a conventional manner by a person sitting, standing, or kneeling inside the vessel.
Yeah.
Okay. And the other question we had about other vessels and age, do we have that yet?
Yes. Okay, yes, I can answer that too. It says in the code, it is unlawful for any person less than 12 years of age to operate any vessel propelled by machinery upon the waters of Tennessee unless the person is under the direct supervision of an adult. This prohibition does not apply if the person is operating a vessel powered by a motor of 8.5 horsepower or less.
So they can, under 12, could operate something, a small motor like a trolling motor,
Yeah.
or 8.5 powers or 8.5 horsepower or less, but nothing more without a license or an adult. Any other questions for legal? Okay. Without objection, we'll go back into session. Any other questions for the sponsor? Seeing none, if you're ready to vote, we'll open the board and try that one more time to vote on this bill. All in favor, vote aye. Or all opposed, vote no. The board's not working again, so we will call the roll once again.
Alexander. Alexander votes aye. Bain. Bain votes aye. Darby. Darby votes no. Doggett. Doggett votes yes. Fritz. Fritz votes no. Grills. Halsey. Halsey votes no. Hurt. Hurt votes no. Jones. Jones votes aye. Reedy. Reedy votes no. Shaw. Shaw votes aye. Stinnett. Stinnett votes aye. Travis. Travis votes no. Vital. Vital votes aye. Martin. Martin votes aye. Todd. Todd votes aye. Mr. Chairman, you have 9 ayes, 6 nays.
Thank you for that. House Bill 940 as amended moves on to Finance, Ways and Means.
Thank you, Mr. Chairman, committee.
Next, we have item number 4, House Bill 67 by Representative Terry. Do I have a motion? We have a motion. We have a second. We have a second on House Bill 667. Representative Terry, you're recognized.
Thank you, Chairman and Committee. And I do have an amendment that makes the bill, amendment number, drafting code 006219.
Okay, that's what we have. We have a motion on the amendment and a second. Does this make the bill?
Yes, sir.
Okay, well, if the committee would like to put that on, without objection, we'll be voting on putting the amendment on. This is drafting code 6219. All in favor, say aye. Opposed? The amendment goes on the bill. So you're recognized on the bill as amended.
Thank you, Chairman and Committee. As we're facing a solid waste issues in Tennessee, in particular in Central Tennessee area, we're looking for information and alternatives on how we can address this situation. And so what this bill does, it creates an advisory task force on solid waste to examine and review issues related to solid waste. The task force shall focus its examination and review on innovative processes for the disposition of solid waste and shall review all aspects of the disposition of solid waste that the task force determines to be necessary, including but not limited to landfilling, recycling, agricultural uses, incineration, and energy production.
Any questions for our sponsor? Seeing none, we'll be voting on House Bill 667 as amended. Clerk, please call the roll.
Alexander. Alexander votes aye. Bain. Bain votes aye. Darby. Darby votes aye. Doggett. Fritz. Fritz votes aye. Grills. Grills votes aye. Halsey. Halsey votes aye. Hurt. Hurt votes aye. Jones. Jones votes aye. Reedy. Reedy votes aye. Shaw. Shaw votes aye. Stinnett. Stinnett votes aye. Todd. Todd votes aye. Travis. Travis votes aye. Vital. Vital votes aye. Martin. Martin votes aye. Mr. Chairman, you have 15 ayes, no nays.
Thank you, sir. House Bill 667 as amended moves on to Finance, Ways and Means.
Thank you, Chairman and Committee.
Next, we have item number 5, House Bill 1137 by Chairman Boyd. We have a motion, a second. Representative Boyd, you're recognized, and I think you have an amendment on this bill.
Thank you, Mr. Chairman. Yes, that's amendment drafting code 4107.
That's what we have. We have a motion, a second on the amendment that rewrites the bill, I believe. So without objection, we'll be voting on that drafting code 4107 going on the bill to amend it. All in favor, say aye. Aye. Opposed? The ayes have it. It goes on the bill. You're recognized on the bill as amended.
Thank you, Mr. Chairman. This is a pretty simple bill. This would require TDEC to, within 10 business days of receiving the material from a soil scientist, to either approve or deny a septic permit for a subsurface sewage disposal system under 750 gallons. Mr. Chairman, I would move passage.
Any questions for the sponsor? Seeing none, if you're ready to vote, clerk, do we need to open the board or call the roll? It is open now. We'll try it. Nope, it's not working, so we'll call the roll again.
Alexander. Alexander votes aye. Bain. No. Bain votes no. Darby. Darby votes aye. Doggett. Fritz. Aye. Fritz votes aye. Grills.
Aye.
Grills votes aye. Halsey. Aye. Halsey votes aye. Hurt. Aye. Hurt votes aye. Jones. Reedy. Aye. Reedy votes aye. Shaw. Aye. Shaw votes aye. Stinnett. Aye. Stinnett votes aye. Travis. Aye. Travis votes aye. Vital. Aye. Vital votes aye. Jones, or excuse me, Martin. Aye. Martin votes aye. Todd.
Aye.
Todd votes aye. Mr. Chairman, you have 13 ayes, 0 nays, 1 present not voting.
Thank you, Mr. Clerk. House Bill 1137 as amended moves on to calendar and rules. Clerk, if you can find me some baling wire, I'll have Chairman Grills work on this system, the voting system. Next, we have item number 6, House Bill 1139 by Representative Boyd. We have a motion. We have a second on your bill. Do you have an amendment, sir?
Mr. Chairman, I have amendment drafting code 6939.
We have a motion on the amendment, and we will, this is a late filed amendment, but it is clarification. We have a motion to consider this late file amendment. We have a second. Any opposed? Without objection, we'll be considering this amendment. So we are now considering this amendment. Have a motion on the amendment. We have a motion. We have a second. We have a second. So all in favor of putting drafting code 6939 on the bill, please say aye. Opposed? The ayes have it. You're recognized on the bill as amended, sir.
Thank you, Mr. Chairman. And committee, just to give you a little backstory on what's going on here. I have an apartment complex in Wilson County that receives its water from one of the hardest water utilities in the state of Tennessee. And at some point, TDEC inadvertently or somehow figured out that they were softening water. And there is a rule at the federal level, at the EPA, that says that if you soften water for more than, I think, 5 or 6 units, then it is considered a water treatment system or essentially a public utility. So this is the only apartment complex in the state of Tennessee that is currently being regulated by TDEC. We are currently working with our federal partners and trying to get some clarification and perhaps get the EPA to take that wording out so that it doesn't have to be regulated. But we've gone back and forth, and what this amendment does is it acknowledges that, yes, because of that rule, it is a public utility, but we're going to step down the testing on this to a lot lower level than a traditional public utility system that would be pumping water out of the river and treating it for consumption. So what this amendment does is it requires the facility to monitor consecutive systems for influent and finished water for hardness, alkalinity, and pH on a quarterly basis and sodium on an annual basis. Mr. Chairman, I move passage.
Okay, thank you for that. Representative Jones, you're recognized.
Thank you. To the sponsor, I just was reading the fiscal note, and on the fiscal note, it says this proposed legislation may jeopardize federal funding of up to $20 million from our nonpartisan fiscal review team here at the legislature. Can you speak to that? And does that seem still in line with how you explained the bill? Because how you explained it is different than how it's explained in the fiscal note. With that funding being jeopardized. So can you clarify?
Thank you, Mr. Chairman. Yeah, I'm so glad you brought that up because that was the problem that we had with the original amendment was no matter how we moved forward, we were going to encounter the possibility of losing federal funding, which would put a fiscal note on it that would have essentially killed the bill. So yesterday, in kind of the 11th hour, sitting down with TDEC, we said, what if we acknowledge that this is instead of pushing back and trying to get this carved out, we say, okay, it's a water treatment facility, but it's different than normal water treatment facilities. And TDEC pretty much said, if you'll change the wording to that and you will continue to allow us to test, then there is no risk of losing federal funding. So the amendment that we just put on the bill has no fiscal.
Fix the voting issue. So they're working on that right now. Okay, now everybody can log in. The microphones are active. So Representative Boyd, I think you got interrupted.
Mr. Chairman, do you want me to start over on that?
Maybe just hit the summary.
The fiscal note on the amendment that we just adopted is different than the one that you mentioned, Representative Jones. So there's no risk of losing federal funding now. We corrected that in the amendment.
Representative Jones?
Did the fiscal review committee have time to give a fiscal note for this new amendment since it was untimely filed? Because I didn't see one. The original fiscal note was $20 million at risk of losing from the federal government. And so is there a fiscal note that you have that we don't have? Okay. And in that one, they said we won't risk losing any money.
Representative Boyd?
Thank you, Mr. Chairman. That is correct. Yeah. Yes, sir.
Thank you.
Thank you for that. Any further questions? Any other questions from members? Seeing none, if you're ready to vote, we'll be voting on House Bill 1139 as amended. Clerk, please open the vote. Well, I'm logged in and it's not working, so we're gonna call the roll again.
Alexander votes aye. Bain? Bain votes aye. Darby? Darby votes aye. Doggett? Fritz? Fritz votes aye. Grills? Grills votes aye. Halsey? Halsey votes aye. Hurt? Hurt votes aye. Jones? Jones votes aye. Reedy? Reedy votes aye. Shaw? Shaw votes aye. Stinnett? Stinnett votes aye. Travis? Travis votes aye. Vital? Vital votes aye. Martin? Martin votes aye. Todd? Todd votes aye. Mr. Chairman, you have 15 ayes, 0 nays.
Thank you, Ms. Clerk. And House Bill 1139 moves on to calendar and rules as amended.
Thank you, Mr. Chairman, committee.
Next, we have item number 7, House Bill 1149 by Representative Butler. Do I have a motion? I have a motion. Do I have a second? Okay, I have a second. Representative Butler, you're recognized on House Bill 1149.
Thank you, Mr. Chairman. I believe we have an amendment we need to put on this.
You have drafting code, sir?
That is 6920.
Okay, we have drafting code 6920 members that has been added to dashboard this morning. It is untimely. If you're so inclined to take that without objection, we will accept this untimely filed amendment. And I know we had some issues with getting this drafted correctly and found some mistakes yesterday. So we have a motion on the amendment. We have a motion. We have a second. So we have a motion second on drafting code 6920. It makes the bill. So without objection, we'll vote on that. All in favor, say aye. Opposed? The ayes have it. The amendment goes on the bill. You're recognized on the bill as amended.
Thank you, Mr. Chairman. I appreciate you working with us on this legislation. There was a drafting area and this amendment corrects that issue. And so it's probably caused some folks some undue heartburn in the drafting area, and we apologize for that, but legal helped correct that yesterday. So anyway, this amendment will do a couple of things. As we mentioned in subcommittee, it will create a pilot program with the Department of Revenue on tracking the sales tax that is collected on paddle sports items. And if you look in the amendment, there's about 13 items that are listed in the amendment that they will track to see how much revenue that is being collected. They will work with retailers to track those nexus codes. Having some technical difficulties. There we go. So that will help us track the paddle sports industry to see how much revenue the state of Tennessee is collecting on this industry. And then number two, in working with the paddle sports industry and TWRA, the paddle sports folks have come to the table and offered to invest 42 cents for every time a kayak or a canoe gets put in the water, excuse me, to help TWRA maintain these ramps. And right now they're paying nothing. So they have come to the table and working with TWRA, and there are 2 restrictions in here that prevent TWRA from adjusting this 42 cents with a 2-year sunset on it. Now, TWRA will be able to maintain and police, for lack of a better term, the ramps, deal with any issues, those kinds of things. All it does is put a restriction to prevent TWRA from being able to cause, increase the fee or any kind of adjustments like that. And with that, Mr. Chairman, I'll renew my motion. Be glad to answer any questions.
Okay, you mentioned this restriction. Does it have a time frame on that restriction of them being able to raise these rates?
Yes, Mr. Chairman, it's a 2-year sunset and it comes off, and then that'll be reverted back to the rulemaking process.
Representative Fritz, you're recognized.
Thank you, Mr. Chairman. Sponsor, thank you for the time yesterday and help me better understand what you're doing with this. Just to be clear on the record, I'm not gonna have to pay 42 cents every time I drag my canoe across the road and into Watts Bar. This is just for the paddle boat or the paddleboard industry, correct?
Representative Butler?
Yes, that is correct, Representative Fritz. This is an investment by the paddle sports industry into maintaining TWRA ramps. So this is only for commercial paddle operators, and they have come to the table and offered this to make an investment in these ramps.
Representative Fritz? Okay, no further questions. Yeah, Representative Vital?
Thank you, Mr. Chairman. And thank you for bringing this to question. There's a lot of open-ended discussion. Obviously, we've eliminated the fact that it does involve any fishing or restrictions on fishing around piers or water ramps. With this new process, will it designate any special parking or control the parking at ramps and interfere with those who choose to use the ramps for their own personal use?
Representative Butler?
Thank you, Mr. Chairman. No, and to go a little bit deeper in this, right now, the commercial paddle sports industry is filing a report with the number of times they put canoes and kayaks in the water. They're already doing that. So that's how the investment from the paddle sports industry will be calculated. It also provides them a parking pass for them to be able to park in these parking lots. So right now, they're not contributing anything to this. So TWRA will still have the right to regulate those parking lots, still have the right to help coordinate those ramps and getting the public folks in there that are using the private guy that's either boating or fishing or kayaking or whatever activity he's in doing.
Representative Vital.
Back to the parking passes. Currently, they drop off paddle boarders at these ramps. The parking areas are very limited in most of them. With parking pass, will this give them priority over individuals who desire to paddle board?
Representative Butler.
Thank you, Mr. Chairman. No, it will not. It will not give them priority over anything. And most of these commercial operators, they do this day in and day out. So they're very efficient. They pull up, they unload, they get their folks off, their customers, and they get them in the water because obviously they want folks to be enjoying the water. So thank you for that question.
Members, if you would,
Thank you.
please log back in. We're going to try this again. But any other questions for our sponsor on the bill as amended? Chairman Martin.
Chairman Butler, so I live between the Ocoee River and the Squatchy River. If I'm understanding this correctly, if I go to the Ocoee River and I get some company to take me there, there's not a fee for them, correct? But there would be one for if I was to go down the Squatchy River. And my question is why?
Representative Butler.
Thank you, Mr. Chairman. There is already an agreement on the Ocoee River to address what we're trying to address. That's already been addressed in different legislation. So the Ocoee River is excluded in this amendment because there already is a fee. So that way there's not any additional cost on the Ocoee.
Chairman Martin.
But there would be an additional cost if I go down the Squatchy River and use one of these commercials. I'm going to pay this 42 cents extra to this company that's going to pay this ultimately.
Representative Butler.
Thank you, Mr. Chairman. Well, no, these commercial paddle operators have come to the table and said, we want to invest in these ramps because we want to be able to maintain these ramps and help be a part of what it takes to keep these ramps usable for everybody.
Okay, I'm good.
Okay. Any further questions or comments? Okay. Chairman Doggett.
Thank you, Mr. Chairman. So is this going to restrict access for other patrons of the boat ramp to be able to get access to it? Are these paddle boat operator companies, are they going to have first priority when at the boat ramps?
Representative Butler.
Thank you, Mr. Chairman. No, this does not prioritize commercial paddle operators in any way at all. They are already using these ramps right now. So all the activities will continue the same thing. The only difference is now they're making an investment in taking care of these boat ramps.
Representative Doggett.
Thank you, sir. But if they're paying a fee for usage of this ramp, are they going to be able to route me out when I'm trying to get my boat in and out of the water or have access there at the ramp? Because they've paid to be there, whereas I, as just a citizen of this state, have the rights to enjoy that boat ramp.
Representative Butler.
Thank you, Mr. Chairman. No, this is not going to prioritize anybody over anybody else. The boat ramps will be accessible by anybody, whether it be a public like yourself that's bringing their personal kayak, or whether it's a bass fisherman, or whether it's somebody putting their boat in to go water skiing. Nobody's going to receive any type of priority.
Representative Doggett.
Okay, thank you.
We do have a couple of folks on our list that want to testify on this bill. So I would ask for Mr. Horace Tipton and Mr. Blake Parsons to approach if they would like to speak, and we will recognize them. We'll give each of you 3 minutes to have a statement, and if the committee chooses to ask questions of you, then we will have time for that. We'll start with Mr. Tipton. State your name, who you're with, and you'll have 3 minutes, sir.
Thank you, Mr. Chairman, and thank you for the opportunity to be in front of y'all this morning. I'll be very brief and then turn it over to Blake. And I think our concerns with the bill, stem from, as respectfully as possible,
Excuse me, Mr. Tipton, I made a mistake. I have to go out of session to recognize you. So without objection, we'll go out of session. We're out of session. Now you can continue. Thank
Horace
you.
Tipton, Tennessee Wildlife Federation. Again, thank you for the opportunity to be in front of y'all today. I think our concerns here stem from a slightly differing interpretation of the language on the amendment today. Our primary concerns are in section B1 of the bill, which say the agency shall not, through any other means, including rulemaking, impose any restrictions or requirements to a commercial paddle-craft operator related to their operator's permit, parking lot pass, or annual permit. We read that and as not allowing the agency to potentially to regulate and direct traffic on those parking lots and boat ramps. And the reason we're concerned about that has to do with the history of this. This user conflict has been going on between anglers and commercial operators for quite a while. In 2018 and 2019, this legislature passed a couple of different bills that gave TWA the authority to regulate commercial paddlecraft operators, and then also set up the Paddlecraft Advisory Commission. For whatever reason, that fix has not been implemented in that time since then. And what my organization's been pushing for since that time is that that fix be implemented. What's needed here is for TWA to assess these situations river by river, and because the nature of the problem is different on each river, right? And create reasonable compromises that preserve the user experience for all users on the rivers. Those compromises likely include things like limitations on where and for how long somebody can park, or limiting the number of boats that can go down a river at a particular boat ramp at a different time. And currently, the way the amendment reads, we still read that as tying the hands of TWRA and not allowing TWRA to implement those potential solutions to this issue. We do read this as potentially prioritizing one group's access over another by not allowing TWRA specifically to restrict commercial paddlecraft operators, and still allowing potentially to restrict the access for anglers and fishermen and other boaters. So with that, I'm happy to take any questions, and I'll turn it over to Blake.
Okay, thank you for that. Mr. Parsons, you're recognized.
Thank you for my time today to talk to you about this. My name is Blake Parsons. I own a fly shop in town, Fly South Outfitters. Been in business here for 25 years, so small business. It's got a long track record of handling these issues and being a part of this conversation. I've been fishing in Tennessee for nearly 30 years and working as a fly fishing guide on our state's rivers and lakes for the last 10 years, holding a Tennessee guide license since its inception in 2015. I'm the owner of the Fishing Return Outfitter. We're a small business, like I said, that is impacted by this issue. All of Tennessee's lakes and rivers deserve proper and capable oversight for fishing and boater safety. I think the oversight absolutely includes boat ramps and access points, which are typically kind of centers of conflict in my experience. As a user of all these boat ramps, I really welcome and encourage TWA's authority in overseeing operations, regulations, and fees for usage. Boat ramps are access points that are inherently part of the state's waterways, and oversight and regulation of boat ramps can't really be effectively separated from the oversight of the water for which the boat ramps provide access. In addition to this major concern I have with the legislation, my small business depends on Tennesseans' abilities to safely access fishable water and boat ramps. Overcrowding on our state's rivers and lakes by commercial paddlecraft operators has already negatively impacted my business and will continue to do so with detrimental effect. Myself and my customers buy fishing licenses as required by the state, and those license dollars fund TWA's operations and oversight and regulations of state boat ramps. This bill would prioritize access for commercial operators by requiring these commercial paddlecraft operators to pay very little in comparison to anglers. In this scenario, anglers will continue to be the funders of TWA by a huge margin, while TWA will be prohibited from doing the job that these license dollars specifically pay for. Without proper and capable oversight of boat ramps by TWA, including license fees and usage, Tennesseans will have negative experiences accessing public water via public boat ramps, and my business will suffer when these negative experiences drive my customers away from our state's wonderful fishing opportunities. TWA has been an excellent partner to anglers in this state, ensuring the safe operations of boat ramps, effective management of our fishing waters. This legislation is simply a solution in search of a problem that does not exist, and I strongly urge you to vote no on the bill.
Thank you for that. Any questions or comments for our guests? Don't have anybody on our list. So seeing none, we will go back in session. Thank you both for being here. We are back in session. We're back on the bill as amended. Representative Fritz, you're recognized.
Thank you, Mr. Chairman. Just one thought, one comment, and one question for the sponsor on the bill. Article 1, Section 29 of the Tennessee Constitution talks about free access to the Mississippi River. Obviously, our founders thought it was important to have free access to the rivers. And while it specifically mentions the Mississippi, I'll leave it to legal as to, Mr. Chairman, whether we determine that to be all river systems. But these boat ramps that you're referring to are often co-located with where perhaps a bass fisherman or a tournament fisherman may go in, but it's a different setup. Are you aware of the setup for these paddleboard launches, Representative? And if so, can you talk a little bit about that? Because I think that may be getting confused a little bit.
Representative Butler.
Thank you, Mr. Chairman. Well, let me put a couple clarifications in there. First of all, these ramps are currently being shared by lots of different folks utilizing the rivers and so forth, whether it be a commercial bass fisherman or whether it be a paddle sports operator. And I do want to point out that TWRA is neutral on this legislation. So I don't think them being neutral is something that we should overlook. I think that's very important because the first thing is if they had an issue with it, they would have been here to testify. They are neutral on this legislation after we have worked with both parties, TWRA, and we have worked with the paddle sports folks to come up with this. TWRA, and talking with the director directly, has no plan at the moment to try to restrict ramps or the use thereof by anybody. And to your point, Representative Fritz, I don't think it's fair to any industry, whether it be paddle sports, whether it be bass fishermen, whether it be my family and I taking a boat to go water skiing on a river. I don't think it's fair to restrict anybody's access at any time during the day. And so this legislation doesn't do that. Now, I will say that I think there has been a history in the past where the paddle sports industry, the Tennessee Wildlife Federation, and TWRA have had some challenges in working together. And I think with legislation like this, now that the fact that everybody has come to the table, I think it's an opportunity for those relationships to be restored so that we can all work together, so all Tennesseans and or folks that are visiting the state can utilize and enjoy the resources that we have. Thank you, Mr. Chairman.
Thank you for that. I don't have anybody else on my list. Anyone else have a question for the sponsor on this bill? Okay, seeing none, if you're ready to vote, clerk, please, are we going to try the board again? All right, we'll try that. We'll open the vote and it's working. So all in favor, vote aye on your station. If you're opposed, vote no. Clerk, please take the vote.
Mr. Chairman, you have 8 ayes, 6 nays, 1 present not voting.
House Bill 1149 moves on to Finance, Ways and Means.
Thank you, Mr. Chairman. Committee.
Next, we have number 8, House Bill 24 by Representative Hemmer. We have a motion. We have a second. Representative Hemmer, you're recognized on House Bill 24.
Thank you, Mr. Chairman, members of the Ag Committee. This bill would increase penalties for trespassing and other related game and fish violations from $10 to $50 today, up to $500 decided by a judge. I started working on this bill recently when I got a trail cam pic of my turkey leash showing a gentleman who was not in a leash carrying a turkey. It was a very violating feeling. It's created some safety issues, but thankfully TWRA was able to find the individual and dealt with the situation for the landowner. But I came to learn that trespass has become a really, really bad problem, big issue for landowners and lots of repeat offenders and suspects, according to TWRA law enforcement. This problem has been exacerbated because now you have these cell phone trail cameras, and so you're seeing a lot of the people actually getting caught now. Unfortunately, the penalty is not it's not substantive enough to deter this behavior. So this problem has really gotten bad, and the penalty has not changed in statute since 1961. So these fines are still in that $10 to $50 range, which if you have a lease, you can understand it's a lot cheaper than a lease. So work with TWRA to go through these antiquated fines through statute and update them to increase the penalty, and appreciate their efforts on this legislation. With that, thank you for your consideration.
Thank you for that. Do we have any questions or comment for the sponsor? Seeing none, if you're ready to vote, we'll be voting on House Bill 24. All in favor, clerk, please open the board. All in favor, vote aye. All opposed, vote no. Has everyone voted? Does anyone wish to change their vote? Mr. Clerk, please take the vote.
Mr. Chairman, you have 14 ayes, no nays.
House Bill 24 moves on to Finance, Ways and Means.
Thank you, committee. Appreciate it.
Next, we have item number 9, House Bill 130 by Representative Renault. We have a motion and a second. Representative Renault, you are recognized on House Bill 130.
Thank you, Mr. Chairman and committee.
You have amendments?
We added on last week. Do we add it on again each time?
We do. Yes.
Okay. It is 6123.
We have a motion on drafting code 6123 and a second. If you'd like to put that on the bill, all in favor say aye. Opposed? The ayes have it. Amendment goes on the bill. You're recognized.
Thank you very much. HB 130 expands Tennessee's food cottage law. Back in 2022, you guys passed the Food Freedom Act. And what we're looking to do with this is to expand the sale of homemade goods to also include poultry and dairy. This will give farmers, small producers, and emerging entrepreneurs greater opportunities to keep food local and strengthen our economy. I did work closely with Department of Agriculture on this bill. I reviewed 10 other states who have similar policies to make sure that we're balancing food safety with economic freedom. The bill does require that food items will comply with federal regulations and any future state laws, as well as it specifically permits sales directly from the producer to the consumer. We already trust our neighbors when we go to potlucks or bring home cooked foods to maybe a mom who has had a baby and to other community gatherings with few, if any, reports of safety concerns. So this bill simply extends that trust to local food sales, ensuring that customers have more choices to purchase food locally and to give more small businesses an opportunity to thrive. With that, I'll answer any questions.
Thank you for that. Any questions or comments for our sponsor? Representative Halsey.
Thank you. Thank you for the bill. We've fought a lot of this stuff for the last 10, 12 years. This means now that a whole bunch of people who want to buy local, they don't all have to be 10 of them all own one cow and have 1/10 of it. This voids all that, right?
Representative Renault.
This is specific to someone who wants to make a homemade item out of their home and not have to go through the inspection or permitting process. So they would just be able to now make a chicken pot pie and sell it to their neighbor.
Okay, it's not the whole cow. Thank you.
Okay. Representative Doggett.
Thank you, Mr. Chairman. I worked on something similar to this it's probably been 4 years ago now, but it was, had a ginormous fiscal note on it because we were trying to do some incentives for folks to be able to do this from their home. So I'm glad that you're bringing this legislation.
Representative Vital.
Thank you, Representative, for bringing this bill. I know you've worked very hard prior to coming to the legislature on this and now that you're here, but help me understand what labeling is required or of any on this type of product.
Representative Renault.
Thank you. Thank you for the question. Manufacturers in these settings also still have to label it. They will have to label the items in the food just as they do with any other things, the primary ingredient first on down to the ingredients there are fewer, less of the whatever's in the product.
Representative Vital.
So it'll also list the manufacturer and a potential expiration date.
Representative Renault.
They will list the producer's name and information will have to be on there. So if someone were to purchase it, they would know who to go back to. As far as the expiration date, this is a consumable. You're going to it's going to be a chicken pot pie. You're going to want to eat it pretty right away. I don't know that there's a provision specifically as to an expiration date. We're not looking for shelf stable items here.
Representative Vital.
Thank you for that clarification. Appreciate it.
Any other questions? Representative Jones.
Thank you. I just wanted to say thank you again for this bill. This was, I think, one of the good bills passed in this committee. So I just want to appreciate you. And we got a lot of emails from small sellers, farmers, local farmers about this bill. And so you see a lot of support from the community for this. So thank you for doing this.
Thank you.
Representative Grills. We do have, okay, I'm getting a nod that he'll pass. Okay, question's been called. If there are no objections to that, clerk, please open the board to take the vote. All right. Clerk, please call the roll. Take the vote.
Alexander. Alexander votes aye. Bain. Bain votes aye. Darby? Darby votes aye. Doggett?
Yes.
Doggett votes aye. Fritz? Fritz votes aye. Grills? Grills votes aye. Halsey? Halsey votes aye. Hurt? Hurt votes aye. Jones?
Aye.
Jones votes aye. Reedy? Reedy votes aye. Shaw? Shaw votes aye. Stinnett? Stinnett votes aye. Travis? Vital? Vital votes aye. Martin? Martin votes aye. Todd? Todd votes aye. Mr. Chairman, you have 15 ayes, 0 nays.
House Bill 130 as amended moves on to Finance, Ways and Means.
Thank you, Chairman.
And I will add one personal comment there. I had visited a church Sunday afternoon and there was a lot of the potluck you mentioned, and someone had a coconut pie that was to die for. It had calf slobber on it that was that tall. And if I could have bought it, I would have bought it, but it wasn't for sale. So thank you for that. Next, we have on our agenda, item number 10, the long-awaited House Bill 543. We have a motion and a second. Representative Vaughn, you are recognized on House Bill 543.
Thank you, Mr. Chairman and committee. I think I have an amendment that needs to be adopted.
Yes, sir.
Let's see, 543, that would be amendment number 6658.
6658 is what we have. Do I have a motion on the amendment? We have a motion second on the amendment. If you're ready to add that to it, all in favor say aye. Opposed? The ayes have it. Amendment drafting code 6658 goes on the bill. So you're recognized on the bill as amended.
Thank you, sir. That rewrote the bill. And what this legislation attempts to do is to make sure that political subdivisions who provide utility services to areas outside their boundaries are able to continue, the people who rely on those services are able to continue using those services, and that local political subdivision won't be able to shut their sewer system off without going through the study by the Tennessee Board of Utility Regulation. It also creates a requirement that if someone has allowed for a sewer pipe to be constructed on their property, whether the specific easement language says they can or cannot enter into that pipe, if there's capacity in that pipe, then they can't be precluded from joining that. And what the basis behind this bill is that we're trying to keep political subdivisions from controlling land use outside their corporate boundaries by using utilities as means to do that. So that's the basis and premise of the bill.
Thank you for that. We have Chairman Grills on our list.
Thank you, Mr. Chairman.
Call question. Okay. Previous question's been called. Any objections? Seeing none. Clerk, please take the roll.
Alexander? Alexander votes aye. Bain? No. Bain votes no. Darby? Darby votes aye. Doggett? Doggett votes aye. Fritz? Fritz votes aye. Grills? Grills votes aye. Halsey? Halsey votes aye. Hurt? Hurt votes aye. Jones?
President.
Jones votes present. Reedy? Reedy votes aye. Shaw? Shaw votes aye. Stinnett? Stinnett votes aye. Travis? Travis votes aye. Vital? Vital votes aye. Martin? Martin votes aye. Todd? Todd votes aye. Mr. Chairman, you have 14 ayes, 1 nay, 1 present not voting.
Motion carries. House Bill 543 moves on to Finance, Ways and Means as amended.
Thank you, Mr. Chairman and committee.
Next, we have item number 11, House Bill 612 by Representative Vaughn. Do I have a motion? We have a motion and a second. Sir, you're recognized on House Bill 612.
Thank you, Mr. Chairman. If I could attach Amendment 5569 to it.
That's what we have. We have a motion and we have a second on drafting code 5569. If you'd like to put that on, all in favor say aye. Opposed? The ayes have it. The amendment's on the bill, sir. You're recognized.
Thank you, sir. 2 years ago, the General Assembly passed legislation that instructed TDEC to provide credit in the same amount of the amount granted under a general permit when calculating compensatory mitigation when altering wetlands. That was basically if you had if you had 0.4 acres that you were having to get an individual permit for, because you could get 0.25 without mitigation, then the difference between the two was actually what you needed to do. This takes the same concept to stream mitigation, and I shared with the subcommittee, town, it's not within my district, but is in eastern Shelby County. They're building a public road project. A general stream alteration permit would have allowed them 200 feet of alteration without having, and this was putting a culvert in, without having to provide compensatory mitigation. As it were, because of the slopes and the design, they had around 215 feet, and it wound up costing the citizens of Arlington over $500,000 for that 15 feet in excess of the two. So what this does is says, if it's okay for you to get 190 feet for free, if the cumulative is 300, then you're only having to mitigate the 110. And that's the basis of the bill.
Thank you for that. Any questions or comments for our sponsor? Seeing none, if you're ready to vote, clerk, please take the vote.
Alexander? Alexander votes aye. Bain? No. Bain votes no. Darby? Darby votes aye. Doggett? Doggett votes aye. Fritz? Fritz votes aye. Grills? Grills votes aye. Halsey? Halsey votes aye. Hurt? Hurt votes aye. Jones? Jones votes present. Reedy? Reedy votes aye. Shaw? Shaw votes aye. Stinnett? Stinnett votes aye. Travis? Travis votes aye. Vital? Vital votes aye. Martin? Martin votes aye. Todd? Todd votes aye. Mr. Chairman, you have 14 ayes, 1 nay, 1 present not voting.
Thank you, Mr. Clerk. Motion carries and House Bill 612 as amended moves on to calendar and rules. Next, we have the third in our Representative Vaughn show today. We have item number 12, House Bill 541. Do I have a motion? We have a motion and a second, sir, and I believe you have an amendment for us.
Yes, sir, I do. It is drafting code 6502.
That's what we have. We have a motion and a second on the amendment. All in favor of putting the amendment on the bill, say aye. Opposed? The ayes have it. You're recognized, sir, on the bill as amended.
Thank you, Mr. Chairman. And for the members of the subcommittee, I apologize for repeating this, but I think it is important to be heard. Presently today, well, first let me start with this. Is that since 1977, the Water Quality Act of 1977, which established TDEC's purveyance over the water quality in our state, environmental regulatory environment has continued to increase pressure with regards to the things that it takes to comply to deliver clean water to our citizenry. That has come that is all well and good, well-intentioned, but seems as over the last 50 years, something has fallen by the wayside through the rulemaking, and that's its impact to private property rights. What this bill does is try to take the private property right, kind of take the thumb off and move it fractionally back in favor of the property owner. TDEC regulates isolated wetlands as a water of the state, regardless of its benefit to the environment. Anything designated as a water of the state, and it can include tractor ruts, clogged ditches, feedlot, roadside ditches. They're all treated the same as a high-quality wetland ecosystem. like you'll find around Reelfoot Lake or maybe the Ghost River section of the Wolf River in West Tennessee. What we're trying to do here is bring our laws into alignment with other states and many of our border states that do not regulate isolated wetlands at all. As it stands today, Tennessee has one of the most progressive liberal regulatory environments similar to those that you'll find in New York, Vermont, Oregon, or maybe California. Now, in 1923, the Supreme Court of the United States ruled that these isolated wetlands were not waters of the U.S. anymore. They removed them from Federal Clean Water Act regulations. And the original bill that I filed, which is what I really think we should be doing today, but this is, like I said, that would be raising the meter a little bit more, but I don't think that in the spirit of compromise, I can get there. But our original bill sought to mirror the results of that ruling and place us on the same regulatory footing as 24 other states in the country. So we were trying to get us on the same regulatory footing as 24 other states, including our border states. This amended language greatly reduces what we were hoping to achieve by compromising on the limits of required permitting to levels that were similar to what the Commissioner of TDEC presented in a summer study last summer. And Chairman Todd, I know that you've done some work on that, and we appreciate that very much. I view this bill as a starting place. Now, for us as we continue to look at this, now what does this bill do? First off, one thing that I've discovered during this 3-year journey of trying to impact this is that I requested a comptroller study of who TDEC directs mitigation dollars to, how much they are, and how much the permitting is, and was told that they could not produce such data because of the way that the data is tracked. So what this does is this requires annual reporting of where TDEC directs mitigation money so that we can easily ascertain which NGOs are profiting. It also acknowledges and differentiates between the quality and value of various types of wetlands because, again, today, one is the same. And we all know from our eyesight that that's not typically the case. It establishes the levels of permitting for various types of wetlands based upon their resource value. It reduces or eliminates the amount of mitigation required for the alteration of the lowest value wetlands. And it also presumes that a wetland resource inventory report prepared by a third-party wetlands professional is correct if conducted in accordance with the specified methodology provided by TDEC. And again, hopefully we believe that this should stop the present practice of treating mud holes like they're high-quality ecosystems. We believe this is going to save folks money. We think that this will lower, and when I say folks, I mean citizens. The biggest providers of dollars into mitigation funds these days are TDOT and municipalities. That's my suspicion. Of course, they couldn't produce data at that time, but they will be moving forward. And so it's also going to hopefully result in lower housing costs. We know we have an affordability crisis in housing, and we hope that this will address that. And so, Mr. Chairman, I'm happy to answer any questions.
Thank you, Representative Vaughn. And we do have folks here to testify. And if y'all would entertain that at this point, we will go out of session and hear from these folks. So without objection, we are out of session. I'll call up Mr. George Nolan, James Ward, Sarah Houston, and Ryan Jackwood. I can pick which seats you'd like, and then we'll start with Ms. Houston first, and then proceed to the gentleman, maybe start on my right and work our way to my left. So Ms. Houston, state who you are, who you're with, and you have 3 minutes.
Thank you, Chairman. Thank you, Committee. My name is Sarah Houston. I serve as the Executive Director of Protect Our Aquifer. I hold a master's in earth sciences, and I've been studying the Memphis Sand Aquifer for nearly a decade. Protecting wetlands that's critical for West Tennessee's water future. The Memphis Sand Aquifer is one of the most prolific groundwater resources in the country. It provides high quality water, fuels our communities, it fuels our agriculture, and it fuels our industries. And as the demand for clean, sustainable water grows, our aquifer is poised to be one of Tennessee's most valuable economic assets. But without recharge, there is no aquifer. We must protect the wetlands that sustain it. Now, there's been discussion about how much wetlands contribute to aquifer recharge. And the truth is, recharge depends on location, geology, hydrology. But we have heard some confusion that all wetlands sit on thick clay layers that could prevent recharge. We've talked quite a bit about this. And that simply isn't true because we don't know every single point. Wetlands exist in a variety of geologic settings. Sometimes there may be some clay. Sometimes wetlands sit on or near exposed sands in the Memphis and Fort Pillow aquifers with much higher recharge rates. And that could be similar to the sandy soils that we see in these upland ditches and streams that provide a lot of recharge. So when clay is present, it doesn't mean that recharge isn't happening, but it does mean that water is filtered. It's treated very slowly before it reaches the aquifer. Now, clay binds to contaminants. It removes heavy metals and PFAS forever chemicals and can improve water quality before it infiltrates deeper. And that's exactly what the Tennessee Water Quality Control Act intends to do, ensure that our water remains clean and plentiful. So we do have a local example of how quality and quantity are connected, and that's at Memphis, where Protect Our Aquifer is based. You know, that city developed way before our wetlands laws existed. And so we're seeing groundwater declines that impact water quality. We talk about 2,000-year-old artesian well water, but that's becoming a myth. Our water levels have dropped so much that it's impacted water quality. We have seen in the Memphis light gas and water well fields that we have modern water, meaning low quality water and a much greater potential for contamination is happening right now. That's why we at Protect Our Aquifer are working on local solutions like water reuse for industrial cooling, specifically pushing for TVA and XAI supercomputer to reuse our wastewater, and that actually might be coming to fruition. But the truth is, you know, we can degrade our water quality by reducing that recharge, and that would absolutely continue to occur without our wetlands protections. So we don't want to make the same mistake that Memphis made decades ago. We're in a post-Sackett world. These states are going to have to decide how our own wetlands protections are going to continue. And we're at a fork in the road. You know, some states argue that Tennessee, you know, passing this can make Tennessee more competitive, but there are states that are raising their standards. Colorado just passed a wetlands bill.
Ms. Houston? Yeah. Well, thank you for that. And sir, you're recognized. Identify yourself, please.
Thank you, Mr. Chairman. My name is Ryan Jackwood. I'm the Science Director for the Harpeth Conservancy and hold a PhD in ecology with 10 years of experience working on wetland science. My previous testimonies have focused on the data and science of wetlands, like we estimate that over 300,000 acres of isolated wetlands exist in Tennessee, that wetlands improve water quality, reduce flooding, improve drought resiliency, and provide habitat for food and many of our endangered and charismatic wildlife. But today I want to describe an experience I had in 2014 that highlights what can happen when we don't value and protect our wetlands. On August 2nd, 2014, I was living in Toledo, Ohio, going to school as a PhD student at the University of Toledo. I woke up on that morning and turned on the news to find out that myself, along with almost 500,000 other people, were under a do not drink advisory for tap water. We couldn't drink tap water or use it for cooking, and we're even being told not to brush our teeth or shower with tap water either. This advisory lasted for 2 days, and the chaos that occurred during those 2 days was astounding. Bottled water sold out within hours of the advisory. Ohio's governor ordered the National Guard to deliver pallets of bottled water and water purification systems to residents of 3 different counties that were impacted. People waited for hours for bottled water to be delivered, and hospitals also had to wait for water deliveries and had to prioritize only emergency surgeries during those 2 days. Restaurants essentially had to shut down during that time. Every citizen and business was impacted in one way or another. The Toledo water crisis, as it was named in the news outlets, occurred because too much of a toxin called microcystin was in Lake Erie water, where the Toledo water treatment plant gets their raw water. This toxin is produced by algae when too many nutrients are present in water, and those nutrients were coming directly from water flowing off the landscape, entering rivers and flowing to Lake Erie without being captured within a wetland. Now, a brief history. 150 years ago, a massive wetland called the Great Black Swamp, about 2/3 the size of Florida's Everglades, existed in Northwest Ohio and filtered water before it flowed into Lake Erie. Today, only remnants of that wetland still exist, and Ohio as a whole has lost over 90% of its wetlands. Since 2014, Ohio has been scrambling to reverse this by pumping money and resources into preserving and restoring wetlands with programs like the Great Lakes Restoration Initiative, the Wetland Reserve Enhancement Partnership, the H2 Ohio statewide wetland grant program, and many more. In 2020, Ohio had to invest an initial $172 million in their H2 Ohio program alone and increase that to $270 million just this past year. In Tennessee, we fortunately have only lost 60% of our wetlands as opposed to the 90% lost in Ohio. Living next to a Great Lake, you assume that water is unlimited, but it was quickly found out that clean water is very limited. I'm not suggesting Tennessee will soon have its own version of Toledo water crisis, although in 2019, a 200 to 300 mile long algae bloom was producing the same toxin in the Ohio River, and health advisories impacted both Ohio and Kentucky. And last year, Meads Quarry Lake near Knoxville along the Tennessee River contained a similar type of algae producing the same toxin, microcystin, that was so abundant a health warning was issued to local residents. Not only do wetlands reduce nutrient loading to our lakes and rivers that ultimately drive algal.
Thank you, sir. We'll have time for some questions. Mr. Nolan?
Thank you, Mr. Chairman. My name's George Nolan. I'm a native Tennessean. I'm a cattle farmer, and I'm also an environmental lawyer. I work for the Southern Environmental Law Center, and I am grateful to address this committee. You're being asked to make major changes to the legal framework that has protected Tennessee's wetlands and allowed for significant growth for a long time. For the last several decades, Tennessee law has protected our state's wetlands and provided developers with a financial incentive to avoid destroying those wetlands when possible. During those same decades, Tennessee has experienced tremendous growth. Yet, now this committee is being asked to remove important conservation guardrails and to turbocharge the pace of development during a time when Tennessee is already the 8th fastest growing state in the nation, and we're losing farmland to development at a rate of approximately 10 acres an hour. Healthy and abundant wetlands benefit all Tennesseans because they recharge our groundwater systems, protect us from flooding, help keep our drinking water clean. But when we destroy wetlands by filling them with asphalt or concrete, we cause several big problems. First, we mess up our groundwater systems, allowing our springs, streams, and aquifers to dry up more quickly and for longer time periods during drought. Second, when hard rains come, our neighbors and communities will suffer more flooding without wetlands available to soak up that water. And third, without wetlands being there to slow water down and filter out pollutants, stormwater runoff into our drinking water sources will be dirtier. Unfortunately, water quality in our beautiful state is on a path of steep decline. In 2010, 15 years ago, 32% of Tennessee's assessed waterways were considered too polluted for activities like swimming and fishing. In 2020, that number jumped to 55% polluted. And today, the percentage of polluted assessed waters stands at nearly 60%. This bill would make matters worse by removing legal protections for the spongy filters that clean our drinking water and provide habitat for wildlife. So we respectfully ask this committee not to make such a dramatic change. Thank you.
Thank you for that. And Mr. Jackwood, you're recognized.
Thank you, Chairman Todd. And members of the committee, thank you for your time. My name's James Ward. I'm with MRW Environmental. I'm a resident of Sparta, Tennessee, and my experience in our great state expands manufacturing, mining, real estate development, transportation, insurance, and currently environmental consulting for the last 20 years. We filed our appearance here in opposition to this legislation. However, our intent is to address certain nuances within the bill that we feel need further attention. The regulatory pendulum often swings from total destruction to not being able to do anything. And so we understand that there needs to be some change from time to time. And I think this bill is moving forward with that. And we don't disagree with it in total. The fact is everyone values vibrant commerce, clean air, and clean water, because we cannot survive without either. Our company has always believed that commerce and the environment must coexist because neither can survive without the other. Representative Vaughn represents a part of the state where an ancient aquifer provides clean water to all his constituents. Until recently, it was believed that this aquifer was protected by an impermeable clay layer. However, as evidenced by the governor's environmental award of 2024, it's been determined that this aquifer is not impermeable, as previously thought. This underscores the reality that we as humans are capable of contaminating even the most protected resource designed by our Creator. The truth applies not only to Western Tennessee, but also to our state and nation as a whole. Tennessee's founders recognized that there are 3 distinct regions in Tennessee. These are all different within the state, and they're represented by the 3 stars on our flag. Each is unique in its own way. Our state's environment mirrors this diversity. West Tennessee, for example, contains 5 times the wetlands of East Tennessee, 4 times that of Middle Tennessee, or 3 times that of Middle Tennessee, and 5 times that of East Tennessee. To regulate them uniformly would be a mistake. Each region has a distinct ecological difference. We believe more consideration should be given to these differences before we pass such a blanket legislation for all 3 regions. Some of our concerns are the disclosure of private information from mitigation companies. NGOs are one thing, private companies are another. I'm sure nobody on this committee would like to disclose their sales in a public forum. Neither should private mitigation companies. Third-party wetland professionals needs to be addressed. I don't know if anybody in here knows one. I only know one, and I've been in the business 20 years. They're hard to find, so the legislation as written leaves no latitude to change who we can get to do.
Thank you, Mr. Warden. I apologize for getting your name wrong a moment ago. Y'all set in a different order. So we have one person on the list so far. Representative Jones, you're recognized.
Thank you. And thank you all for being here. My question was for Mr. Nolan. Can you kind of speak to what are some of the biggest problems with the specific wording of the amendment in your view?
Thank you.
You're recognized.
Thank you for Representative Jones. Yes. Paragraph B1 of the amendment allows for so-called low-quality wetlands, isolated wetlands of up to an acre in size to be filled without any sort of mitigation or notice requirements. And the reason that that's such a big deal is that 80% of Tennessee's isolated wetlands are less than an acre in size. So you would be authorizing the destruction of those wetlands, not only without any mitigation being required, but without the developer being required to tell anybody about it, to even notify TDEC that these wetlands are being destroyed. So there will be no data that is kept as far as the destruction of these wetlands is concerned. Secondly, paragraphs B2 and D of the amendment allow developers to ignore the cumulative impacts of the wetlands they're destroying within their site plans. And that's a really, really big loophole because it does not require developers to do honest math when they have a site plan that includes many different wetlands that are less than an acre in size. Paragraphs B24 allows wetlands to be destroyed without any sort of buffer requirements. And buffer requirements are important for water quality because they require developers to back off our lakes and back off our streams and leave green stuff along those waterways to protect water quality. And it's this amendment does away with those types of requirements. And then finally, paragraph B6 allows future commissioners of TDEC to up the acreage percentage exemptions that are contained again in this bill. So this legislature would be giving its power to a future commissioner of TDEC to make the acreage exemptions even more dramatic.
Representative Jones.
Thank you so much.
Chairman Grills, you have a question.
Thank you, Mr. Chairman. I really have a statement more than I have a question, but I just want to tell you, I know the last 3 years we've had this conversation over and over and over again. And the decorum that you guys have shown, I really appreciate it. We've not necessarily agreed on the topic, but you've had acted like ladies and acted like gentlemen, and I really appreciate that. In today's political climate, we don't always see that when you have a controversial issue. So I'm very grateful that we can have a working relationship where people can see things from different sides and yet be civil about it. So with that, I say thank you.
Representative Shaw.
Thank you, Mr. Chairman, and thank you all for being here.
I'll have to admit, I've heard more about wetlands in the last 2 years than I've heard all my life. To you, sir, you've really made a lot of good sense. Everybody have, but what you said, you made a lot of good sense. But here's what I want to ask you, from my experience with wetland areas. Maybe if you had enough concrete or asphalt, but can you really hide a wetland just because you fill it in with dirt within a certain period of time? Won't it come back? Won't you see some water somewhere? And I hope I'm asking you a question that makes sense. But if you fill something in today, 6 months from now, if it's a true wetland, would you not see some water, evidence of some water somewhere?
This for Mr. Ward or Mr. Nolan? Okay, Mr. Nolan.
Yes, I apologize for
Okay.
not calling your name right. Yes.
Sure. Thank you, Representative
Yeah.
Shaw. I think the short answer is the water is going to go somewhere. And it's going to depend on what the wetland got filled with and where that water is going to go. So wetlands have a tremendous ability to soak up and hold tremendous amounts of water. And that's in part a function of how they're shaped and also what plants are growing in the wetlands and actually take up that water. So, if you fill it with concrete, that water is going to run off faster than if you just fill it with, a level lawn that's got fescue growing in it. But, one of the concerns, I think, with eliminating wetlands is, the water is going to go. And so you will impact your downstream neighbors when you destroy wetlands.
Representative Shaw.
Thank you for that. And I will tell you that through all of this, that has been my main concern is who at the end of the line, who really are left holding the bag here. Because your insurance, none of that. It's no clauses, nowhere to take care of that kind of thing. So now you've invested in your home and this is all you've got. And now you got a wetland problem. I've really been struggling with this because I think what I want to make sure is that whoever owns that property at the end of the day be treated fair about wetlands, and we don't do anything to make sure that they're treated unfair. But I thank you for your comments. I appreciate it. Thank you.
Thank you, Representative Shaw. Don't have anybody else on the list. Thank you all for being here with us today. Have two other folks on our list, Miss Mallory Kirby and R.J. Gibson. If y'all would come take a seat, and we'll let Miss Mallory go first. Just to state your affiliation, and you'll have each 3 minutes. Ms. Kirby, you are recognized.
Thank you, Mr. Chairman. My name is Mallory Kirby, and I represent Build Tennessee Housing, an association of developers from across the state of Tennessee. We appreciate the dedicated work of Chairman Vaughn and Chairman Todd over the last 3 years to arrive at the legislation before you today. As you know, Tennessee is facing serious challenges when it comes to housing affordability. According to data from the National Association of Home Builders published last month, the median new home price in Tennessee is $406,090. The income needed to qualify for the loan at the current rate is $118,918. 74% of Tennesseans are unable to afford such a home. A $1,000 increase in the price of a median priced new home will further price 3,456 Tennesseans out of the market. Burdensome overregulations, such as those addressed by this legislation, can be a significant contributor to these challenges. According to a recent study on Tennessee's post-Sackett wetlands program by the Environmental Law Institute, the current mitigation cost in Tennessee is $50,000 to $80,000 per mitigation credit. Most mitigation is completed at a 2-to-1 ratio, resulting in typical mitigation activities costing between $100,000 and $160,000 per acre. In some cases, the cost of regulation is so high that the project does not move forward and communities never see the economic benefit of the proposed project. For example, a developer had a 15-acre isolated wetland, isolated meaning non-WOTUS wetland, that was created by a beaver dam. TDEC's environmental scientists determined that it was high quality due solely to the presence of 2 single purple state-listed flowers. The mitigation ratio for high-quality wetlands is 10-1 and would have required a 60-foot buffer. This land did not sell, and as a result, that community lost out on 300 units of multifamily housing that would have produced $750,000 in annual tax revenue for that local government, in addition to the landowner's loss of a $3 million sale. In another example, the levee of an old man-made farm pond had been breached, resulting in 0.33 acres of low-quality isolated wetland. Another 0.15 acres of low-quality isolated wetland was located elsewhere on the property. Current regulations require these to be added together, even though the 0.15 acres would have been covered by the current general permit and required no mitigation had they been considered separately. Mitigation for this site cost $38,000 in addition to the $10,000 design cost incurred by the developer and took 6 to 9 months to work through the process. Even with this legislation, Tennessee will maintain its status as one of the most stringently regulated states in the country for non-WOTUS wetlands. While we hope this legislation would go further in providing regulatory relief, we believe this is a step in the right direction. Thank you, Mr. Chairman, the committee.
Thank you. Mr. Gibson, you're recognized.
Thank you, Mr. Chairman. My name is RJ Gibson. I'm with the Tennessee Chamber of Commerce and Industry. Good afternoon, members of the House Agricultural and Natural Resources Committee. 2 years ago, the General Assembly considered HB 541, legislation that would have placed Tennessee's regulatory jurisdiction over isolated wetlands in line with most of our peers in the Southeast. After the U.S. Supreme Court's Sackett decision that limited the federal government's jurisdiction to only wetlands with a continuous surface connection to navigable waterways, the jurisdiction of most state wetland programs in the Southeast immediately snapped back to match the federal government's jurisdiction. However, Tennessee remained a severe outlier by continuing to regulate all wetlands, requiring permits and costly mitigation in order for property owners to alter their land. In its original form, House Bill 541 would have restricted the state's jurisdiction to only those waterways that the federal government regulated, like many of our peers. The Chamber and other business groups supported that effort. However, after hearing from legislators and a variety of stakeholders, we heard loud and clear that Tennessee was unique and that a more tailored approach was needed to adequately regulate the state's wetlands. So we worked in good faith throughout 2023 and 2024 to find a solution that worked for everyone. This current bill is the culmination of that work. The bill has changed dramatically since it was initially introduced back in 2023 and now reflects a balanced approach that will reduce costs and provide certainty for business owners, home buyers, and other property owners, while continuing to provide protection for Tennessee's abundant natural resources. Let me be clear, this is a limited deregulatory effort by comparison to other states. Currently, Georgia, Alabama, Mississippi, South Carolina, Arkansas, and 18 other states have no regulatory jurisdiction over wetlands that the federal government does not regulate. For those wondering, our current wetlands regulatory regime currently compares to California, New York, New Jersey, and Minnesota. So what does this bill do? Ultimately, it is about protecting the property rights of Tennesseans. It raises the bar for the state to tell property owners what they can or can't do with their property. It allows for property owners to impact small wetlands of limited resource value without having to spend tens or hundreds of thousands of dollars to obtain a permit and mitigation credits. And it ensures that artificial wetlands created by tractor ruts and other human activity do not fall under the regulatory jurisdiction of this state. These reforms will decrease housing prices for Tennesseans and make Tennesseans more economically competitive compared to our peers. The Chamber is proud to support this legislation and is extremely grateful for the input and work of this committee over the last few years to study the issue and help us come up with a solution that will work for Tennessee. Thank you.
Thank you, Ms. Gibson. And we do have some questions for you guys. Representative Jones, you're first on the list.
Thank you, and thank you all for being here. I'm trying to trace your argument that by destroying wetlands, it's going to bring down housing costs. It seems like it will increase the profit of developers and their interests, but it does not seem like this will bring down our housing costs. And how will it bring down our housing costs when we'll see increased flooding? And then what happens then? 1 acre of wetland holds 1 million gallons of water. So with increased flooding, there's increased cost. How does it decrease housing cost? when it removes the beauty that makes people want to live in certain areas? How will it decrease housing costs when you destroy all the things around our communities that make people want to live there, that make these places that people want to move from all across the nation to live in our state? It just seems counter to the interests of Tennesseans by saying that this will bring down housing costs, when again, it seems like this bill is being presented by lobbyists and it's going to only profit developers and it won't trickle down to Tennesseans. Can you explain your logic behind that?
Ms. Kirby?
Thank you for the question. So as with any aspect of commerce, expenses to the developer or the manufacturer or whatever the case may be most often get passed along to the consumer. And that's the same in this industry. The cost of regulation does get passed along to the consumer. In terms of the flooding question and the impact to the surrounding area, my members tell me that currently they are required, their engineers are required to show the city engineer or county engineer that the runoff rate of speed after development can't be any greater than pre-development. So that is already being taken into consideration. Those issues are already being addressed, at least by my members, and that is their experience.
Representative Jones?
Both of you listed some states, I believe, that have passed policies to remove protections, because I don't think we're talking about regulation. These are protections for wetlands. And I went to go look, I was just Googling, and none of those states had lower housing costs than they did before they removed protections for wetlands. So again, this argument is not logical. Every state you listed that removed protections from wetlands post-Sackett, their housing costs are not going down. In fact, it's just hoarding more wealth for these developers and it's not bringing down housing costs. Do you have any instance of a state where housing costs have went down because of this legislation passed? Because I couldn't find any.
Ms. Kirby?
Most of the states that did not have non-WOTUS protections were that way well prior to the Sackett decision. So I don't know that would have an impact, but no, I do not have data on the housing prices of other states.
Representative Jones?
So we have no instance that this will bring down housing costs. The only facts that we have before us are, number one, that this bill will threaten our citizens with increased flooding, which we've heard from scientists and ecological groups, people who study this. Even TEMA was here last year when I was on this committee warning us against this. What we heard was that this will threaten endangered species. What we heard is that this will decrease the beauty that people want to see in their community. What we heard was that this may threaten these places for our future generations. What we heard were farmers who were against this. What we heard were, every group against this, as I listed in our subcommittee meeting. And so I'm grateful that you all came here. Thank you for sharing your data. I know that you have a job to do. You are paid to be here, and that's okay. But I'm so concerned because every message we got from people in the state, not one of them was for this bill. This is the first time. Last week, we had an out-of-state lawyer come from Washington who came to speak for this bill. And so I'm glad that we have some folks from our state, but I'm really struggling to see this as a compromise because as we heard, do you all have any position on the fact that there's no cumulative impact? So say you have 20 acres you're trying to develop and there's 9 1-acre wetlands. All those wetlands can be destroyed without any type of reporting. Can you speak also to the concern about, removing protections for riparian buffers, which exist before, and what this could do to both the development land and also for the stability of that space for decades to come? Can you speak to that a little bit?
Ms. Kirby?
So the legislation as amended does not remove all protections from isolated wetlands. There are still going to be a number of isolated wetlands that are going to maintain protections under this amended bill. And anything over 2 acres is going to not have any change in the permitting process unless it falls under the artificial definition. And then it will depend on quality from there. So I think each instance is going to have to be looked at individually. I don't think we can make a blanket statement that all of these isolated wetlands are now going to be destroyed or or have the ability to just do whatever that the landowner wants with them under any circumstance.
Representative Fritz?
Thank you, Mr. Chairman. Just one quick question for our guests here. You mentioned, ma'am, $1,000 price increase in a home impacts a number of potential buyers. Could you give me that number again, please?
Sure. And this is from the National Association of Home Builders data. A $1,000 increase in the price of a median priced new home will further price 3,456 Tennesseans out of the market.
Representative Fritz.
Thank you, Mr. Chairman. Just quickly, I appreciate that data because that, facts are stubborn things. And everything that we do to create an inflationary impact upon home ownership hurts the least of these the most. So thank you for bringing that data.
Representative Shaw.
Thank you. You mentioned the fact that the city engineer would be involved in if there were water runoffs. What about in a subdivision? Is that what we're talking about? Are we talking about individual lots or both?
Ms. Kirby.
I believe it would be both. Any kind of development that is presented, I believe, would have to go through the same process. And there are also, stormwater requirements as well as FEMA floodplain requirements that are looked at when these developments are taking place. So all those factor in.
Representative Shaw.
Thank you. I think I can see where the legislation is helpful when it's a small amount over and against being a larger amount of property. That's why I asked that question. I mean, if you talking about 2 acres, it's pretty easy to get your eyes on 2 acres and know what you're looking at compared to 10, 15 acre space where you build a lot of homes. So I was just wondering if that extra layer of protection would be there for people who might be building like in a subdivision as such. But I think you answered that. Thank you.
Representative Vital.
Thank you, Mr. Chairman, and thank you all for being here. I think we have all learned a lot about wetlands. I've been in many occasions now when the discussion of artificial wetlands is a discussion item. I never thought it would be. I think there's been great progress to try to identify how we really eliminate the challenges that are faced with development as it relates to tractor rut situations. They go on and they cost a lot of money. At the same time, wetlands are an important part of the sponge of our earth, protecting us from flooding, purifying our water, and making sure that we have habitat for wildlife and for the enjoyment of humans. This bill has created great consternation. There's been a lot of discussion. A lot of individuals and stakeholders came together. A report was put together. Some items were taken from that, but a lot was left on the table. That's what gives me great consternation. And so with that, I appreciate what we're trying to do to help lower the cost of housing. I'd like to really see it. I think people across this state would like to see it, not just because we have deflation or slowdowns in the economy and prices are dropping, but real cost and savings. But at the same time, we have to protect the environment. We're investing across the state to make this a great place to live, work, retire, but also to develop. But we need to make sure that 25 years from now, we don't have unintended consequences from this. So thank you all.
Any comments from either one? Okay. Don't have anyone else on our list. So we appreciate you being here. And without objection, we'll go back into session. We're back in session. We're back on the bill as amended. Representative Jones.
Thank you. And to the sponsor, I understand that you don't understand the severity of what this bill is doing. I understand that, and I feel bad that you're not thinking about the next generation. And I know that you tried to make this about private property rights. And so my question is simple. Do you think that our children have a right to clean water? Do you think that they have a right to hold a bog turtle, to see a great heron? Do you believe that our children have a right to be free from increased flooding? Do you believe that our children have a right to see the beauty of our natural resources that make Tennessee a special place to live.
Representative Vaughn?
Of course I do. I believe all of those things are right. But what I also think our children have a right to do is live in a society where the government doesn't place a burden of regulations on them that produces no real results. Nothing but inflationary costs that someone somewhere has to pay. That's what I believe.
Representative Jones, last question.
The only people who we know will benefit from this are private developers. And that wealth will not trickle down to everyday Tennesseans, which is why we have no everyday Tennesseans supporting your bill. I've been in this committee for 3 years now, and not once has a regular person come before this committee and say, I want this bill. Not once has a regular person, a constituent, emailed and said, we want this bill. Instead, thousands said, we don't want this bill. And so I think that the people of Tennessee are against this. I think that the people of Tennessee understand the severity and the danger of this legislation. 80% of wetlands will be impacted by this bill. And I think that's a scary thought for our future. And so I know that there's been all the pressures to get this through. And I just hope that one day you see that this is the wrong course. And I hope one day that you think about us, because we are related here. We're all connected here. And I hope that you see that connection and don't get bogged down by the noise of lobbyists down here. But I hope that you listen to the people, and I hope that you hear their cry to stop this for their children and for your children. Because when we say we want to oppose this, it's not just about my children, but I'm trying to fight for your grandchildren too, my friend. And I hope that you see that this is the wrong way.
Representative Vaughn?
I'm good.
Okay, Representative Shaw.
I just called for question on the bill.
Question's been called. I don't see I have anybody else on the list. So if you're ready to vote, clerk, please take the vote.
Alexander? Aye. Alexander says aye. Bain?
No.
Bain votes no. Darby? Darby votes aye. Doggett? Doggett votes aye. Fritz? Fritz votes aye. Grills?
Yes.
Grills votes aye. Halsey? Halsey votes aye. Hurt? Hurt votes aye. Jones?
No.
Jones votes no. Reedy? Reedy votes aye. Shaw? Shaw votes aye. Stinnett? Stinnett votes aye. Travis? Travis votes aye. Vital? Vital votes no. Martin? Martin votes aye. Todd? Todd votes aye. Mr. Chairman, you have 13 ayes, 3 nays.
Thank you, clerk. And the committee has approved this House Bill 541 as amended, moves on to Finance, Ways and Means.
Thank you, Mr. Chairman. I appreciate everyone through the past years. I know we've all got topic fatigue on this matter. I hope to not ever be here discussing this with you again. Thank you.
Next, we have item number 13, House Bill 882 by Travis. We have a motion second. Representative Travis, you're recognized on House Bill 882.
Thank you, Mr. Chairman and committee. This bill prohibits TDEC from regulating farm activities involving topsoil, rock removal, or the building of a pond, which such activities are conducted in an area that is less than 3 acres in size, and the property on which activities occur must be on the Greenbelt classification. Thank you, sir.
Okay. Any questions or comments for our sponsor? Representative Fritz. Question's been called. I didn't have anybody else on our list. So without objection, we'll be voting on House Bill 882. Clerk, please take the roll.
Alexander? Alexander votes aye. Bain?
No.
Bain votes no. Darby? Darby votes aye. Doggett? Fritz? Fritz votes aye. Grills? Grills votes aye. Halsey? Halsey votes aye. Hurt? Jones? Jones votes present. Reedy? Reedy votes aye. Shaw? Shaw votes aye. Stinnett? Stinnett votes aye. Travis? Travis votes aye. Vital? Vital votes aye. Martin? Martin votes aye. Todd? Todd votes aye. Mr. Chairman, you have 12 ayes, 1 nay, 1 present not voting.
Thank you, Mr. Clerk, and the motion carries. House Bill 882 moves on to Finance, Ways and Means. Next, we have item number 14, House Bill 175 by Representative Darby. We have a motion. We have a second. Representative Darby, you're recognized.
Thank you, Mr. Chairman. This bill specifies that the Tennessee Fish and Wildlife Commission may promulgate the rules or issue proclamations to allow for the use of drones by an individual or business on private land solely to recover deer that have been wounded while a person was lawfully engaged in hunting. And with that, Mr. Chairman, I'd like to read this also. Current law already allows property owners to use drones on their own land and requires the consent of the property owner to use on another's property. Current law also states that it is illegal to use a drone to hunt or track game. Neither this bill nor any regulations would circumvent or change that. Instead, this bill will carve out the option to use drones solely for the recovery of deer as established through rule.
Thank you for that. Any questions or comments for the sponsor? Seeing none, if you're ready to vote, we'll be voting on House Bill 175. Clerk, please take the vote.
Alexander? Alexander votes aye. Bain? Bain votes aye. Darby? Darby votes aye. Doggett? Fritz? Fritz votes aye. Grills? Grills votes aye. Halsey? Halsey votes aye. Hurt? Hurt votes aye. Jones? Jones votes aye. Reedy? Reedy votes aye. Shaw? Shaw votes aye. Stinnett? Stinnett votes aye. Travis? Travis votes aye. Vital? Vital votes aye. Martin? Martin votes aye. Todd? Todd votes aye. Mr. Chairman, you have 15 ayes, 0 nays.
Thank you, Mr. Clerk. Motion carries. House Bill 175 moves on to government operations. Item number 15, without objection, we're going to roll that to the heel. Item number 16, House Bill 799 by Chairman Grills. We have a motion and a second. Chairman Grills, you're recognized on House Bill 799.
Thank you, Mr. Chairman and committee. This bill is just specifically dealing with Reelfoot Lake. Several years ago, there was a settlement between landowners and blind owners on Reelfoot Lake so that when a person passes away, the blind that they had legal right to became property of the state. And what we're going to do is take those blinds that whenever these people pass away and create a blind system where people can obtain a commercial license and continue to duck hunt and take people as a outfitter at Reelfoot Lake, so that the time, since the beginning of time, they've been hunting Reelfoot Lake for ducks, and we want to make sure that that heritage continues forward. And with that, Mr. Chairman, I'll take any questions.
Thank you for that. Don't see any questions. If you're ready to vote, will clerk please take the vote on House Bill 799.
Alexander? Alexander votes aye. Bain? Bain votes aye. Darby? Darby votes aye. Doggett? Fritz? Fritz votes aye. Grills? Grills votes aye. Halsey? Halsey votes aye. Hurt? Hurt votes aye. Jones? Jones votes aye. Reedy? Reedy votes aye. Shaw? Shaw votes aye. Stinnett? Stinnett votes aye. Travis? Travis votes aye. Vital? Vital votes aye. Martin? Martin votes aye. Todd? Todd votes aye. Mr. Chairman, you have 15 ayes, 0 nays.
Motion carries. House Bill 799 moves on to Government Operations Committee. Next, we have item number 17 by Chairman Grills. Do I have a motion? We have a motion. We have a second. Chairman Grills, you're recognized on 804.
Thank you, Mr. Chairman. I do believe we have an amendment we need to put on the bill, if you
Yes,
would.
sir. Your drafting code.
5874.
We have a motion on drafting code 5874 and a second. If you're ready to put that on, all in favor say aye.
Aye.
Opposed? The ayes have it. Amendment goes on the bill. You're recognized on the bill as amended.
Thank you, Mr. Chairman. And what we're dealing with here is a cell cultured protein. I know this is a lab grown meat is maybe a more street term that we would use. Very hot topic. As a free market capitalist, you hate to just ban anything. I know there's lots of folks out there that love to see us just ban it, but I kind of have a little bit of a issue just banning something. But what we're doing is creating a process by which the Department of Agriculture will have to obtain a permit from the Department of Agriculture. These products cannot be sold in the state of Tennessee as meat. They cannot be labeled as meat, and they have to obtain this permit before it can actually be sold. So what we're doing is giving the Department of Agriculture some jurisdiction over this type of product if it is or ever becomes something that is sold in Tennessee. And with that, Mr. Chairman, that's my efforts.
Okay. Any questions or comments for the sponsor? Seeing none, you're ready to vote. Clerk, please take the vote.
Alexander. Alexander votes aye. Bain. Bain votes aye. Darby. Darby votes aye. Doggett. Fritz. Fritz votes aye. Grills. Grills votes aye. Halsey. Halsey votes aye. Hurt. Hurt votes aye. Jones. Jones votes present, not voting. Reedy. Reedy votes aye. Shaw. Shaw votes aye. Stinnett. Travis. Travis votes aye. Vital. Vital votes aye. Martin. Martin votes aye. Todd. Todd votes aye. Mr. Chairman, you have 13 ayes, 0 nays, 1 present, not voting.
Thank you, Mr. Clerk. Motion carries. House Bill 804 is amended, moves on to government operations. Pass the gavel to Chairman Martin.
Thank you, Chairman Todd. We are on House Bill 0894. Motion and a second. And Chairman Todd, is there an amendment?
Yes, sir. We do have an amendment. It is drafting code 6154.
Motion, second. All in favor of adopting the amendment, say aye.
Aye.
Any opposed? All right, the amendment passes. Chairman Todd, you are in position to share your bill with us.
Okay, thank you for that. And this bill simply constitutes a board of groundwater management that primarily governs our well drillers across the state and make sure that our groundwater resources stay as clean and pure as possible and protect our citizens. And the amendment just simply adds a standard sunset provision on it. So with that, I'll be glad to take any questions.
Any questions? Question on the bill? Oh, hold on just 1 second. Okay, let me back that up just a second and rewind. Chairman Todd, you're recognized.
Thank you. I missed a note I had here. I do have amendment drafting code 5755 that needs to go on the bill as well. It makes the bill.
Motion? Second? Or is any objection to?
Put it on, I'm sorry. Since we adopted the other one first, if we put this one on, it's going to strip it off. So we'll have to reconsider our action on the previous amendment.
Okay, hold on just a second. We made a motion, I think Chairman Reedy did, but we're going to need to get rid of the previous amendment that we had. So Chairman Reedy, could I ask you to?
With
That works? To reconsider our actions? Okay, there's a second? All right. All right. Without objection, we're going to reconsider our actions. Okay. Chairman Todd.
Okay, thank you. Now we will want to put amendment drafting code 5755 on the bill.
Okay. Motion second without objection. Okay. That's added. Now, Chairman Todd.
Now I'd like to add amendment drafting code 6154.
There's a motion second. Any objection? That's adopted. Chairman Todd.
And that makes the bill with the proper sunset provision. So stand ready.
Question on the bill? All right.
Mr. Chairman.
Yep.
One other thing, I would ask that we roll these, if they're, since they're both adopted, we roll them into one amendment as they move forward.
Okay. There's a motion, there's a second.
Legal will take care of that.
Okay. All right. So adopted without objection. All right. So we know what we're voting on here on this bill as amended. Clerk, would you take the roll?
Alexander. Alexander votes aye. Bain. Bain votes aye. Darby. Darby votes aye. Doggett. Doggett votes aye. Fritz. Fritz votes aye. Grills. Grills votes aye. Halsey. Halsey votes aye. Hurt. Hurt votes aye. Jones. Jones votes present, not voting. Reedy. Reedy votes aye. Shaw. Shaw votes aye. Stinnett. Travis. Travis votes aye. Vital. Vital votes aye. Martin.
Aye.
Martin votes aye. Todd. Todd votes aye.
You give us the vote.
Mr. Chairman, you have 14 ayes, 0 nays, 1 present not voting.
Okay, the bill passes and goes to government office. Now we're at item number 19, House Bill 0896. Motion second. Chairman Todd, do we have any amendments?
Yes, sir, we do. Drafting code 4547 that rewrites the bill.
Second, motion second. Any objection? All right, all in favor. It's approved without objection. Chairman Todd, you're recognized to talk about your bill.
Thank you, Mr. Chairman and members of the committee. This bill, also known as the Sound Science and Regulation Act, seeks to ensure that state regulatory action, specifically rules, must be based on the best available science pertaining to drinking water, water pollution control, hazardous substances, or contaminated site remediation, air quality, and solid or hazardous waste. With that, I'll be glad to stand for questions.
Okay, Representative Jones.
Thank you. In subcommittee, I brought up concerns, obviously, that we got about this bill, but I wanted to get some clarification. You said in the amendment in subcommittee that this does not apply to the Department of Health, Department of TDEC. It doesn't apply to those departments. Can you explain which departments it would apply to and give an example of what it would look like to have a sound science policy under that department?
Chairman Todd.
Thank you for that. And in short, I believe, I'm looking over the list here, but I believe TDEC has all of these areas that I just mentioned. So the Department of Environment and Conservation would be the primary recipient of this action.
Representative Jones.
Just so we can have some clarity, are there any policies in TDEC right now that you would imagine not being in line with sound science? Can you just give us an example so we can envision how this bill would play out? Because from my understanding, this would be the first state that has this type of policy. No other state has passed this law. And so can you give us an example of a bill that TDEC has that may be out of line once we pass this so we can understand what we're voting on?
Chairman Todd.
I do not know of any right offhand. No one's come to me and said this is an issue that we've seen in the past, but they have come and said, we see this happening in other states and we want to make sure it doesn't happen here, that we base our decisions solely on sound science.
Okay, final follow-up, Representative Jones.
Thank you. And then for the sake of clarity, can you give us an example? I don't think we can grasp. This just seems so abstract right now. And there's very contentious concerns and there's been letters and debate about what sound science would look like under this. And so can you give an example of a policy or protection that is not in line with what you deem to be sound science? Again, no other state has passed this law. We would be the first. And so for the sake of getting it on the record, can you give us an example of a policy that would be out of line with this policy once it's passed, if there's one in another state that comes to mind?
Chairman Todd.
I would speak hypothetically because I don't have anything in front of me that is a specific case, but I would say if John Doe decided on his own he was going to do a study to see if a certain thing were going on in the environment and bases this study just on his own information that he gathers, and he submits that to a journal and pays them to publish that, then some agency could pick that up and say, okay, we're now going to use this as evidence to pass a rule or regulation in our department that would affect all the citizens of the state, but we're only basing it on this one idea that this guy had that researched it himself, paid to have it published, and that is being done. then that's what this type of thing is to prevent, that we don't base our rules and regulations on things that are not strictly peer-reviewed, sound science that I think any average citizen would say that's legitimate.
Chairman Grills,
Thank you, Mr. Chairman. Question on the bill.
question on the bill. Okay, we're ready to vote on House Bill 896. Mr. Clerk, please take the roll.
Alexander. Alexander votes aye. Bain. Bain votes no. Darby. Darby votes aye. Doggett. Doggett votes aye. Fritz. Fritz votes aye. Grills.
Aye.
Grills votes aye. Halsey. Halsey votes aye. Hurt. Hurt votes aye. Jones.
No.
Jones votes no. Reedy. Reedy votes aye. Shaw. Shaw votes aye. Stinnett. Travis. Travis votes aye. Vital. Vital votes aye. Martin.
Aye.
Martin votes aye. Todd. Todd votes aye.
Mr. Clerk, please read the vote.
Mr. Chairman, you have 13 ayes, 2 nays.
House Bill 0896 passes and moves on to calendar and rules.
Thank you, Chairman Martin. We have one other item on our list that we rolled to the hill, and we are there. Item number 15, House Bill 747. My Representative Fritz, I have a motion and second. Sir, you're recognized.
Thank you, Mr. Chairman and committee, and I have an amendment 4659, which makes this bill.
A motion and a second on the amendment. If you want to put that on, we'll go ahead and do that. All in favor, say aye. Aye. Opposed? The ayes have it. Amendments on the bill. You're recognized on the bill as amended.
Thank you, Mr. Chairman and committee. I'll be brief for this. I would submit to you that energy is the number one commodity in the United States today. So much so that our president has declared a national energy emergency. The legislation that lays before you has been gen-subbed in the Senate. I appreciate you hearing it here in this committee today. But I think it's imperative that we continue this conversation. This is part of a 3-year journey on energy in Tennessee. I think we can lead the nation in producing not only nuclear energy, but other forms to make sure that these lights come on, the heating and ventilation systems that we rely on come on, the potable water and the sewage that we depend on that are powered by electricity are service to this state as we grow. We declared in 2023 that we were going to have an energy policy in Tennessee. Last year, we restructured the State Energy Policy Council. That State Energy Policy Council draws from resources from West Tennessee to East Tennessee to help equip those of us that are either lawmakers or policymakers and how we can lead the nation in what everyone assumes to be nuclear renaissance that's forthcoming, and how we bridge that delta between now and that 8 to 10 year period out when we will apply that Oak Ridge advantage to make sure that we are producing more kilowatts than we need and that we are seeing growth across our state in natural gas and even in crude oil. And with that, Mr. Chairman, I'd ask for your favorable consideration, answer any questions you may have.
Thank you for that. I don't have anybody on my list right now. If you're ready to vote, we'll be voting on House Bill 747 as amended. Clerk, please take the vote.
Alexander. Alexander votes aye. Bain.
No.
Bain votes no. Darby. Darby votes aye. Doggett. Fritz. Fritz votes aye. Grills. Grills votes aye. Halsey. Halsey votes aye. Hurt. Hurt votes aye. Jones. Reedy. Reedy votes aye. Shaw. Shaw votes no. Stinnett. Travis. Travis votes aye. Vital. Vital votes aye. Martin. Martin votes aye. Todd. Todd votes aye. Mr. Chairman, you have 11 ayes, 2 nays.
Motion carries. House Bill 747 as amended moves on to Finance, Ways and Means. Committee, any other business before the committee? Seeing none, we have finished our business for the year, it looks like. So this meeting, this committee will stand adjourned, close subject to the call of the chair.